Court is on the record in a civil action entitled In Re Failure to Obey Subpoena, Dakota Mullen, case number 25 MIS 10. The court issued an order to show cause on June 4th, 2025. The order basically reads that pursuant to Rule 17G of the Ohio Rules of Criminal Procedure, the failure by any person without adequate excuse to obey a subpoena served upon him or her may be deemed a contempt of the court or officer issuing the subpoena. On May 29, 2025, Dakota Mullen was personally served with a subpoena in City of Conneaut versus Ann Headley, case number 25 CRB 105, ordering her to appear on June 4, 2025 at 1:00 p.m. at Conneaut Municipal Court. The court did attach to its order a copy of that service return from the court bailiff indicating that service had been perfected personally upon Ms. Mullen. Ms. Mullen failed to appear on June 4, 2025 pursuant to the court order subpoena. I then issued that order ordering Ms. Mullen to appear today, June 25th at 1:30 p.m. We're starting a little early, to show cause why she should not be held in and punished for contempt of this court for refusing to comply with the court order to appear on June 4th, 2025 in the Headley case. Ms. Mullen is present. She is not represented by counsel. Also present is Law Director John Lewis. Pursuant to Section 2705.02 of the Ohio Revised Code, specifically subsection C, a failure to obey a subpoena duly served or a refusal to be sworn or answer as a witness when lawfully required is deemed an act of contempt. Pursuant to Section 2705.05, a hearing is required in all contempt proceedings. At that hearing, the court shall investigate the charge and hear any answer or testimony that the accused, in this case Ms. Mullen, makes or offers. If the accused is found guilty, the court may impose any of the following penalties. For a first offense, which this would be, a fine of not more than $250, a definite term of imprisonment not more than 30 days in jail, or both. Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You are Dakota Mullen.
Yes.
Ms. Mullen, you were served personally with a subpoena by the court bailiff on May 29th, 2025 in the case entitled City of Conneaut versus Ann Headley. Is that correct?
Yes.
You were ordered by the subpoena to appear on June 4th, 2025 at 1:00 p.m. Do you recall that?
Honestly, with all the subpoenas I've gotten over the past month and a half, I do not recall.
I don't want to hear that, Ms. Mullen. I don't want to hear it.
I understand.
She was the victim in the Headley case, right? Or alleged victim?
Yes, sir.
Poor excuse, Ms. Mullen. So I want to know why you weren't here that day.
I cannot,
Tell me the truth.
I truly cannot recall the day, but I'm sure it was probably a day where there was Todd's case the day before, or the day after, or 2 days before, 2 days after, and I just mixed it up. I don't know. That's all I have to say.
I don't recall, Mr. Lewis, did Ms. Headley's case got dismissed, right? Because of Ms. Mullen's failure to participate or appear?
No, Ms. Headley's case we're having a hearing on it today, Your Honor.
Oh.
Yeah.
Maybe that's why I scheduled it today.
It's scheduled for a final pretrial today.
Okay.
Yeah.
What time is it scheduled?
1:30, Your Honor.
Well, Ms. Mullen, you're not going anywhere because I'm going to defer. I'm not going to take action on on the contempt until I'm assured from Mr. Lewis that you are actively cooperating with him. What your decision about how to proceed on the Headley case is between you and him. I'm not telling you you have to proceed in a certain way or not. But I am directing you to cooperate, and that's what a subpoena is for. You are to cooperate. You are to be here when you're supposed to be here. I will address the contempt proceeding here shortly, and we'll see what happens. So you can go back into the area where victims are normally located until Mr. Lewis needs you, okay? Okay. The court is back on the record in City County versus Ann Headley, as well as in re failure to obey subpoena of Dakota Mullen, 25 MIS 10. I took a recess on this case to allow Ms. Headley's case to go forward. Ms. Mullen was issued an order to show cause as to why she should not be held in contempt of the court for failing to obey a court order to appear on June 4th, 2025 in the Headley case. Before I proceed, I'm going to ask Mr. Lewis. Mr. Lewis, did you find Ms. Mullen's participation to be cooperative?
Yes, Your Honor. Today's participation, she was cooperative, yes.
Okay. What's your position with respect to holding her in contempt of court because she forgot or didn't? She really didn't have a reason other than too much going on. I'm not sure.
Your Honor, I agree with the court's decision to go forward with this miscellaneous charge, and I think that she should be held in contempt of court. She did not give a reasonable excuse other than she just forgot or was confused for not appearing. Thank you.
Thank you. Okay, Ms. Mullen, you are still under oath. What would you like to say in response?
I'm pretty sure I just the traffic court and all of these, and it's no excuses.
Are you high?
No, I'm just really upset because hearing my mom's payments and then my fines and my previous fines and fines of money in it and everything like that, it's just hard to, without me being able to find a job and no other income other than return, it's a lot to think about right now.
Well, we've had some experiences with you, Ms. Mullen, over the past month or two, and you've testified recently in another case. I can't remember which case it was, but it seems like you've appeared before this court quite often here in the last few months in different cases, and I just don't like your appearance. I'm going to hold you in contempt of court for failing to appear on June 4th, 2025. I'm going to suspend 30 days of jail. I'm not going to impose a fine. I will waive court costs, but I am going to order today that you submit to a urine drug screen, and I am going to, once I see the results of that urine drug screen, call you back into the courtroom, and then we'll decide to complete the sentence with respect to probation. Okay, so you're going to submit to a urine drug screen today. Anything further, Mr. Lewis?
No, Your Honor. Thank you.
Ms. Mullen, there will be someone who will assist you in that respect. Thank you. The court is back on the record in failure to obey subpoena of Dakota Mullen, case number 25 MIS 10. For the record, the court has been recording these past few hearings involving Ms. Mullen under the and heavily bookmark. So I made a mistake on that, but we are back in the courtroom to continue the sentence. Ms. Mullen is in court without counsel. Also present was Law Director John Lewis. When I found you in contempt of court, Ms. Mullen, I imposed a sentence of 30 days jail, suspended. I waived a fine. And before I completed the sentence, I ordered that you undergo a urine drug screen. The results did match what my suspicions were. You tested positive for ecstasy, benzos, amphetamines, methamphetamines, and marijuana. Are you currently receiving the treatment services of any substance abuse or mental health agency?
I was working with Signature Health after I got out of the hospital in December. I did not follow through. But I would like to go back to them if I get recommended.
Anything further, Mr. Lewis?
No, Your Honor. I suspected that you did, and you were correct.
Okay, I will, as I said, I'm going to place her on supervised probation with this court. I'm going to order that she submit to a comprehensive diagnostic assessment at Signature Health and successfully comply with any recommended course of treatment. She's ordered to remain drug and alcohol free. She's not to possess or consume any alcoholic beverage or drug or abuse. And she's not to go into, that includes as well pseudoephedrine products, and she's not to go into any bar or liquor establishment for the term of her supervised probation, which will be 2 years. She will have to pay the probation fee and costs, and I will give her until December 31st to pay all costs in this case. I'm advising Ms. Mullen of her right to appeal, without cost, of her right to have counsel appointed on appeal without cost, of her right to have documents provided her necessary to file an appeal without cost, and of her right to have a notice of appeal timely filed on her behalf. Okay, Ms. Mullen, over the next 2 years, you're going to be on probation with us. You're going to be meeting with the probation officer periodically, and he's going to be monitoring your compliance with my sentence. If over the course of the next 2 years you're found to have violated in any way the terms of your probation and sentence, in this case, you do face up to a maximum 30 days in jail. I could extend your probation from 2 years up to a maximum 5 years, and or I could impose more restrictive community control sanctions, more restrictive than what I've already done. So do you understand the consequences you face if you're found to have violated your probation?
Yes, sir, I do.
Yes, go ahead.
I was planning on going back to dancing at clubs, which I don't know if they serve alcohol or not. Am I allowed to?
Yeah, well, here's the way this court operates, Ms. Mullen. First off, a bar is a bar, and so when I order you to stay out of a bar, that means to stay out. Now, if you really want to make that request to me, I want to see a letter from the bar, or from, I should say, not a bar, I want to see the letter from your prospective employer offering you a job on their letterhead, and I want you to make a written request for me that you would like to be able to go to work there. See, we don't operate on speculation, I may work, or I'm going, it's not speculation. I want to see an offer, and then I'll consider it. And I'm telling you, depending on the place that I'm thinking you're asking me to allow you, it's probably going to be a no. But perhaps you might want to look at other more productive employment that's respectful of you and your recovery. Anything else, Ms. Mullen? Okay, thank you. This matter is concluded.
Let's call the case. People versus Jalisa McDow.
Alexander on behalf of the people, Your Honor. Asli Bashir on behalf of Jalisa McDowell.
Oh, Jalisa McDow.
And Your Honor, we would like to address bond in this matter and request the briefest possible adjournment.
Okay. Go ahead. I'll let you address mine before I give you the date, I guess.
Thank you. Before I kind of address the substantive bond in this matter, I do want to address kind of clerical error in another case. The court may see that there's a case out of 14A2, 25203, okay, actually, no, I'll save that for the end if it comes up. Just because it looks like she's being held on another matter for a higher bond than she actually has, at least in the system that
Out of my court?
Oh, sorry, 1482.
So what would you want me to do with that?
Well, in case that was part of your consideration for.
Oh, I see.
Apologies.
You don't want me to change it.
No, I do. Oh, so as far as this matters, yeah.
You can go to Judge Barr, but go ahead.
So as far as this court is concerned, Ms. McDowell is being held on a $50,000 bond. This is the result of an emergency bond motion and the court's order in response to that motion, that hearing on the June 16th. Circumstances have changed since that hearing. My understanding is at that time, the complaining witness was residing very close to where Ms. McDowell resides.
Have the circumstances changed to the extent that the allegation of a knife to the body or hand of a 15-year-old has changed?
Yes.
Well, the charged alleged conduct in the police report, as far as that report, which we have not had any substantive hearings on the merits on that matter, but the report hasn't changed to my knowledge. But we have stood mute on that matter.
Screenshots.
Yeah, and we do. We are gathering discovery on the matter, and I would say in terms of the kind of concerns related to bond about Ms. McDowell being close to the complaining witness, I do believe that the complaining witness, I understand, is residing in Detroit with her grandmother. She no longer resides next door to Ms. McDowell.
I got her moved.
Ms. McDowell also she's been in custody for 15 days on this matter. She is willing to go on GPS tether. She has, support in the court. She has a coworker and friend who is here today. Her sister was planning to be here today, but was not able to. I do think that additionally, the hardship of her being in custody is something I request the court take into account. She's concerned about the security of her residence. She's been informed that there has been potential vandalism and potential people breaking into her home while she's been out. No one else is officially residing there. Ms. McDowell has there's no allegations of Ms. McDowell trying to contact the complaining witness. There's no allegations that she's been making jail calls. She has no intention of contacting the complaining witness in this case, and she understands the seriousness of that. And so I do believe that the being held in custody on a $50,000 bond is excessive in this matter. We can address. Yeah, okay.
You're saying the bond I set was excessive?
Well, at present, given the current
go ahead.
circumstances, which have changed, the information you had before you then is not the same as the information as it is now. Of course, I would not question the court's judgment. But specifically, because of the potential hardship to her and the concerns about her home, the concerns about the fact that she is no longer anywhere near, she won't be anywhere near the complaining witness. And, she has already been in custody for 15 days. The final matter is, she has, she works as a supervisor at her workplace. She's been there for 5.5 years. She is very concerned about, her job. And so I would request, that she be able to be released to work. I understand that one of the release conditions includes a GPS tether. She's happy to go on a GPS tether and follow any conditions this court thinks are appropriate for her to be released. But if the court would consider, her.
Where are the other 2 children?
My kids were left at
Yes.
home attended for 2.5 weeks, sir. And I literally moved my kids to Detroit to my mom. They are safe now, and I did sign my rights over, sir. But my children were left home attended for 2.5 weeks. I sent cash up money to them.
This is Miss McDowell. I don't think we want to address anything with the children right now, other than the fact that they're residing with their grandmother.
I got the move. I just want you to know
yes.
that, sir.
And Miss McDowell, all 3 children are living with the grandmother.
And I've been working from my jail cell for 3.5 hours a week because I had to still provide for my children because I knew that they were home left attended. I have that on recording on the jail cell as well. With the CPS lady, her name is Tiffany Avery, sir.
And to be clear, this is not a conversation involving the children. It was just.
And I've never been accused of anything violent. The other accused, the malicious property destruction, I have a $10 bond, sir, and that is taken care of. And it was you prosecuted her rapist, and that was the
Ms. McDowell, I think if you can just hold off on saying, I think we'll address anything.
I just wanted to speak up for myself, sir, because I'm not a criminal, sir, and I really, really do need to go to work, sir. I've exhausted my funds and I've been taking care of my children for 2.5 weeks. I didn't make contact, but I do know that they were home by themselves. And it just was discovered. And the CPS worker is going to be providing those information as well. I'm sorry, sir.
That is all, Your Honor.
Your Honor, the court's familiar with this case. I'm not going to re-exhaust the motion that we filed. The only thing that I see that's changed since last hearing is that the children have been placed with that grandmother in Detroit. The facts of this case still stand that she is being stabbing her daughter with a butter knife so severely that her daughter needed stitches in her hand. I mean, I have severe concerns, and not only that, she threatened to kill her daughter, and her daughter was so afraid to contact police. She had to have a text a friend to call police because she was so afraid. I mean, I have great concerns, even if she is released, for her children's safety. And this is a very significant case. And I believe in our bond form, our original request was $100,000, so $50,000 as set by the court is appropriate in this case and should remain as set.
Your Honor, if I may address that, there is no history of violent conduct between Ms. McDowell and the complaining witness in this case. The basis of the statements that were just made by the people are entirely the police report in this case.
And
again,
her stitches.
Well, the basis of the allegation that Ms. McDowell is the cause of the injury is based on the police report. That has not been addressed on the merits. And again, there's no history of legal issues or reports of violence between Ms. McDowell and her children. I would say, I don't believe, I would like the court to consider the gravity of holding her in custody on the basis of just the police report at this stage of the case with no allegations that she has violated her.
Telling me it's wrong that the child was at the hospital getting stitches, counsel, and that's what I should consider?
I want the court to consider the fact that that Ms. McDowell has stood mute. The court has entered an octave.
I understand all of that, but you're asking me to consider her hardship and saying that there are certain things that may be objective in that police report that I shouldn't consider that.
I would like the court to consider the fact that Ms. McDowell is no longer going to be anywhere near that child. So if there is a concern about the possibility that that injury may have been caused by Ms. McDowell, which we deny, that would be addressed by that fact, in addition to the fact that there would be a GPS tether as part of her bond conditions.
And I did also want to make the record clear. She does have a previous conviction for domestic violence from 2018. She also has a previous conviction for larceny from 2020, and she also has the pending case of the MDOP with another domestic relationship So I mean, I do have concerns. She does have an assault history, and given this case, I'm concerned that it's escalating from what her previous history is.
Your Honor, none of these cases involve Ms. McDowell's children.
Yeah, but you said she didn't have a violent history. She got a DV conviction. Motion for bond reduction is denied. Bond will continue. Court does call the case of the people versus Barrage Scott.
For the judge. Court shall feast on behalf of Mr. Barrage Scott, who is approaching the podium. Mr. Scott, please state your name for the record.
Dante Scott, sir.
How you doing, Barrage?
All right, just glad to see my family in here, that's all.
Thank you, Judge.
Been here every time for you.
Yeah.
All right.
Thank you, Judge. I believe this is a competency review. My understanding is that we do have a report. Scott is competent, Your Honor.
Yes.
We stipulate that, Your Honor.
And the people?
But also stipulate.
All right. The court, having reviewed the report, would find that the defendant is competent to stand trial. The defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is found competent.
Judge, I'd be asking this might be set for a PCC, and Mr. Scott would like me to address bond as possible.
All right. Probable cause conference will be set for July 10th, 2025, 9 a.m.
Thank you, Judge. I've had a chance to talk to Mr. Scott about the situation, and I've relayed to him how serious of a charge he is facing. Mr. Scott is still asking that I seek a personal bond from on this case, Your Honor. Although the court does see that Mr. Scott is competent, Mr. Scott does indicate that he suffers from a variety of mental health conditions. He indicates that he would love to get this situation resolved. He would love to see this prosecutor's office potentially offer him a mental health court resolution. He says that he's not going to run from this situation. He has family support. He indicates that his mental state is in a much better place now than it was at the time of this alleged event. He indicates that he has a grandmother who is involved in his life and who will help make sure he attends any and all court dates. He indicates he will go to any outpatient or inpatient treatment that the court does require. He also has no objection to being on a tether. He indicates he's willing to just address everything that's going on in his life, Your Honor, that he will not be a problem for Your Honor should the court release him. He's asking that Your Honor consider a reduction in bond or a potential personal bond. But again, I have relayed to him how serious of a charge he's facing. But I believe that's what you want me to argue. Anything else? Mr. Scott says that he's on his medication now, and he's obviously much better when he's on his medication than he is when he's off his medication, and he will stay on his medication should the court allow him an opportunity to be released. And that the nurses in the jail have upped his medication in certain areas and have him on a shot and a pill form.
Yes.
And so his mental mind frame is in a better place, and he will do anything and everything the court asks, but he's asking for potential release.
Response.
I would ask that bond remain as currently set. I appreciate Mr. Easter's advocacy on behalf of his client. I'm struck by the language in the competency report. Mr. Scott affected a volitionally uncooperative response out during the evaluation process and attempted to feign legal knowledge, memory deficits, and symptoms of severe candidly, if you're uncooperative in the underlying competency evaluation, given his criminal history and the facts of this case, I believe that he is a danger to the community and as
Nothing further, Judge.
All right. I am going to deny the defendant's request for a bond reduction in this case. I think the bond is set appropriately. I would further indicate that Mr. Scott's been appearing before this court for quite some time on various matters. And typically I can let Mr. Scott out of custody and come back in, but usually for minor things. Mr. Scott was in custody. I took a chance, released him. He did not make it a week before this came up. Mr. Scott was arrested. So I'm not going to take that chance again, especially since it's
You understand what he's saying
a
to you?
violent case.
Hold on, do you understand what he said to you?
So
He said that he let you out. This happened a
I'm
week
listening.
later.
I know, but he keeps saying the same thing.
Okay.
Saying the same thing that he said.
Okay. I believe Mr. Scott wants to address you directly, Your Honor, if you
go ahead, Mr. Scott.
Listen, Mr. Simpson, I know you kind of keep, going back in the past, right? But this is my life. You know what I'm saying? My grandma's here, my family's here. People are making me look bad. Even a competency hearing, they're making me look bad. I answered everything what I was supposed to answer the right way, and the prosecutor is saying I was I wasn't cooperating the correct way, and I was. It seems like I had to take 2 competency tests. And the first one, he just said what he wanted to say. I'm asking if you release me today, because I got to go see Slay today. They said if I do get released, they're going to follow the same recommendations you will follow if they put me on tether, if they put me in. You never put me in no classes. You never ever put me in no classes or try to do anything like that. I want my days to be filled. If I'm on tether and I have a curfew, I want my days to be filled. I be with my auntie, stuff like that. I go to classes. I go to Don Farms. I need this. I need help. I have a drug problem. I never addressed it like this. But after my sister died last year, she died. She had passed away at 23. I went crazy. I didn't understand half of the things. She had heart failure. It's my grandma. She's 70 years old, something like that. What it happen if you keep me in here and then she just something happens?
Scott,
No, listen.
Mr. Scott, no, you listen. No, you listen.
But
I'm done. I let you out. I gave you a chance. I've given you numerous chances. Saying that anybody's trying to make you look bad, I don't have to go to the past. I let you out. You don't make it 8 days. And now I have you involved in a crime that involves pointing a gun at another person. I'm done.
what do you mean?
Listen,
Can you just let me
motion for bond reduction denied, bond will continue.
Thank you, Judge.
But
Go
you
ahead.
ain't let me speak,
Go
though.
ahead, Mr. Scott.
You ain't even let me speak.
Thank you, Judge.
Let's call the case, People versus Jalisa McDow.
And on behalf of the people, Your Honor. Asli Bashir on behalf of Jalisa McDowell.
Oh, Jalisa McDow.
In your honor, we would like to address bond in this matter and request the briefest possible adjournment.
Okay. Go ahead. I'll let you address bond before I give you the date, I guess.
Thank you. Before I kind of address the substantive bond in this matter, I do want to address kind of clerical error in another case. The court may see that there's a case out of 14A2, 25203, or, oh, sorry. Okay, actually, no, I'll save that for the end if it comes up. Just because it looks like she's being held on another matter for a higher bond than she actually has, at least in the system that I.
Out of my court?
Oh, sorry, 1482.
So
Oh,
what
so-
would you want me to do with that?
Well, in case that was part of your consideration for.
Oh, I see.
Apologies.
You don't want me to change it.
No, I do. Oh, so as far
Well,
as this
but I
matters,
won't.
yeah.
You can go to Judge Barr, but go ahead.
So as far as this court is concerned, Ms. McDowell is being held on a $50,000 bond. This is the result of an emergency bond motion and the court's order in response to that motion, that hearing on the June 16th. Circumstances have changed since that hearing. My understanding is at that time, the complaining witness was residing very close to where Ms. McDowell resides.
Have the circumstances changed to the extent that the allegation of a knife to the body or hand of a 15-year-old has changed?
Yes.
Well, the charged, alleged, conduct in the police report, as far as that report, which, we have not had any substantive, hearings on the merits on that matter, but the report hasn't changed to my knowledge. But we have, stood mute on that matter.
We have screenshots.
Yeah. And we do, we are gathering discovery on the matter. I would say in terms of the kind of concerns related to bond about Ms. McDow, her sister was planning to be here today, but was not able to. The information you had before you then is not the same. Is
To Detroit, to my mom. They are safe now.
well, Your Honor. Even if this of the is
What I get,
Accomplished when I was working with Mr. Guyire is identifying, first of all, that there's a problem. That's how we start solving every problem. So we identify there's a problem. So obviously I'm not a clinician, but I reached out to some that I work with, the Golinskis, and I said, I wanted Mr. Guyire basically screen for every possibility. I want him screened for anger management, domestic violence management, alcohol management, everything. Because I wanted to see the whole plan that I had was, I thought that the best way to tackle this issue is to try to demonstrate to the court that Mr. Guyire wanted to make positive changes in his life. It's not unique. I've done this before. What is unique is the fact that I've never, in many years of practice, had somebody who embraced it in the way that Mr. Guyire did. The reports, the updates, the number of classes he's gone to, the individual counseling. It's not a magic bullet, but what it does do is it demonstrates to the court that Mr. Guyire is making positive changes. And so I did receive a lot of letters talking about that Mr. Guyire is not a good person, and I recognize that. Matter of fact, I recognize historically that what happened this day was a horrible thing that happened. But there's only one way that Eric could deal with it, and that's to go in a positive direction. And sometimes until you really dig deep in, you don't realize that you need help. In talking to both Chance and Alice Golinski, in reading what they had to write about him, and then after he's put in with the men's group, the individual counseling, it inspires me to think that this is not superficial. I want to look good for the judge. I think this is, I want to be a better partner. And I fully recognize and make the statement that Mr. Guyire and his wife's marriage is ending. I get that, but they still have to be able to communicate and get along because they have young children. And I thought, well, geez, if he's going to be the best father, and I've had this discussion with the court that, I try to inspire my clients to be the best version of themselves they can be. Mr. Guyire, admittedly, was not the best version of himself. Matter of fact, he was quite a horrible version of himself, if you believe everything that's in the letters in the police report. But I think when he recognizes the wrongfulness of his actions and seeks to rectify his behavior, not wanting the rest of the world to change around him, but for him to change the rest of the world, I think it shows a lot of growth. So when I look at and I think of the four goals of sentencing, rehabilitation, protection of society, punishment, and sending a deterrent message to others, I always kind of default that if I was a judge, if I was sitting in your position, punishment might be really important. Maybe it wouldn't be. But what would definitely be really important to me is protection of society, because I have an obligation as a judge to make sure that people in society are safe. That's one of the things the judge is doing. I think it's a very important role. If a defendant has engaged in rehabilitative services, in rehabilitative counseling, and is doing more than just the superficial, just getting by, not throwing up reports like Mr. Guyire of excellent participation, good progress, excellent attendance, regular and consistent attendance. I think, although it
does help Mr. Guyire. I think it also helps the court understand that Mr. Guyire is making positive change. He could sit here and he will say he's sorry, and he's really sincerely sorry, but that falls so much on deaf ears, because you and I, as officers of the court, you as a member of the bench, we can't sit here and extrapolate in our minds and imagine in our minds what the relationship between the Guyires were, other than to say that it wasn't good. And the blame can probably be assigned in large part to Eric's conduct, his anger management. And my point in kind of going on about this issue is I want the court to know that sincerely, Mr. Guyire, and I've had a lot of conversations about this, and I think he sincerely wants to be a better role model, a better parent, better partner, better co-parent. And only after he deals with himself and his shortcomings can he even begin that process. I'm fully cognizant of the fact that there's a divorce pending, that there's going to be a child custody determination, and whatever it is, there's going to be some level of talking, getting along, and I just want Eric to be the best he can possibly be. The only thing that concerned me, and I discussed it with Eric, he's going to address it with the court, was I kind of took his defendant's description of the events as minimizing and blame shifting. When I talked to him about it, I said, I don't like that at all. And he said, I did not use my words properly. He said, I told her, the agent, I take full responsibility for what I did, that Brittany has no responsibility here with regards to what happened. And he said, that's not how I feel. He said, I've learned stuff, I've learned new tools in my counseling in order to better communicate. So I look at and there's no jail time recommended, but of course I want to address that issue. Because I'm fully cognizant of the fact that the prosecutors are going to probably ask for jail time. I'm going to describe to the court why I don't think that's necessary in this case. We got a guideline scoring range of 0 to 9 with somebody with no prior record. So we already have an intermediate sanction and a low intermediate sanction at that. And not only that, but on the 0 to 9 range, Mr. Guyire is also admittedly lower on the scale. So the proportionality, I think, would push towards no upfront incarceration. I do recognize that the court said the focus of my sentence is going to be punishment, and that would warrant incarceration. The reason I would ask the court not to consider that is a more of a practical one. I don't want Mr. Guyire to slide backwards. I want him to keep pushing forward. I don't want to miss one men's group. I don't want to miss one individual counseling session. I don't want to miss any of this because he's going forward. I fear that if he had to even go sit for 30 days, that would push him back. Now, I'm not saying that the court deems that that's what's appropriate, that Mr. Guyire isn't going to do it and do it with a smile on his face. My concern is I just want to see him making forward progress. If he had come in, or Mr. Galinsky or his wife had sent in reports where he was just barely doing the minimum, and he was kind of showing up to meetings when he wanted to. That's not what I'm reading at all. So I think a probationary sentence to reinforce and to monitor Mr. Guy's continuation with completing the men's group. He's 21 sessions in out of 39. But rather than incarcerating him, I'd ask the court to consider a probationary sentence. I fully recommend this. It's obviously the court's purview to do what you want to do. But I think that we've given the court as much information about Mr. Guyire. We supplied letters of support for him. I'm surprised his counseling notes. I've tried to give the court everything I can possibly give you to persuade you not to give Mr. Guyire jail, but to persuade you that he is making an honest effort to be a better person. So I know Eric has a prepared statement that he wants to present to the court.
Okay, thank you, Mr. Clayton. I guess I do want to just clarify one thing for the record. I did receive and review the letters of support for Mr. Guyire. And because he's a litigant to the case, the defendant and his liberty interests are at stake, he's entitled to present character witnesses. I was presented with some letters that upon initial glance were apparent to me that they were from supporters of the victim and making claims obviously negative to Mr. Guyire, and that they contain some sort of substantive claims as well. When I noticed that that was what it was about, I did not read those letters at all, because I don't think that that's a proper way for me to consider information at sentencing, because the defense has no ability to cross-examine that information. The victim's not a direct litigant to the case, has certain rights under the Crime Victims' Rights Act that are afforded, including making a statement on her own behalf. But for the court to open it up for just letters from the community, negative toward a defendant, I don't think, I think that would violate the defendant's due process rights. So I did not review the substance of those letters. All right, Mr. Guyire, you don't have to make a statement today, but you're allowed to. Is there anything that you want to tell me, sir?
Yes, sir. So thank you for giving me a chance to talk today. I want to begin by saying how truly sorry I am for my actions. From the moment that it happened, I deeply regretted it. I knew it was wrong. I've carried that with me every day since then. I take full responsibility for my behavior. I'm not here to make excuses. Over the past almost 7 months, I've had a lot of time to reflect, not only on what I did, but what I've lost. I missed so much time with my children, and including a lot of first with my youngest daughter, who was an infant at the time it was happening. Those are all moments that I can't get back. That pain, that absence has been one of the hardest things that I've had to endure through all of this. It's been one of the strongest motivators for me to change also, to be better, not just for myself, but for my kids. Since then, I've made a commitment to do the deep, difficult work of bettering myself. I've been actively involved in both individual therapy and men's group for anger management. I'm learning how to manage my emotions, understand my triggers, and navigate them in a responsible way. I've also been reading and watching a lot of self-help literature, including resources from Jordan Peterson, amongst a lot of others, which have helped me shift my mindset and take ownership of my life. I'm working every day to build stronger coping skills and emotional regulation, not just to prevent future mistakes, but to become the kind of father and person that I want my children to look up to. Your Honor, I don't stand here today looking for sympathy. I stand here to show you that I'm taking real steps toward lasting change. I'm not the same person I was 7 months ago, and I don't intend to ever be that person again. My children deserve a lot better, and I'm doing everything I can to give them to them. Thank you for your time and consideration.
Thank you, sir. Mr. Goodrich, any recommendations?
Yes, Your Honor, I'd ask the court to allow Brittany Guyire to make a victim statement.
Yes, Ms. Guyire, if you want to come forward to the podium here. Good afternoon.
Your Honor, my name is Brittany Guyire, the soon-to-be ex-wife of Eric Guyire. I never imagined myself standing here speaking these words and reliving these moments. But I need you to understand what I have endured, not just for myself, but for my children and for all the women who have been in my position. On November 27th, 2024, my life took a turn I can never forget. That night, I had just come home with my children. It wasn't long before another argument started, something that had become painfully routine. I was tired, desperate for help, and frustrated with his lack of support. He was angry over things that seemed so insignificant compared to the weight I was carrying. As I stood there holding our 6-month-old daughter with our 5-year-old son nearby, Eric began to shout in my face. As he went to finally walk away, he grabbed a freshly opened can off the counter and slammed it in the sink, causing it to splash all over himself. Then, without warning, he turned around and grabbed me. Both hands around my neck, he lifted me off the ground, ignoring the fact that I was holding our baby. My son stood behind him, begging him to stop, but he didn't care. He carried me and my 6-month-old daughter toward the front door, squeezing tighter. Before we even made it there, everything went dark. I blacked out. When I came to, our daughter was face down on the floor. I still replay this moment in my mind. The way I struggled to process what had happened, the way I feared for her, the way I feared for myself. Thankfully, she wasn't seriously hurt, but I strongly believe the only reason Eric let go of me that night was because she fell. If I hadn't have dropped her, I really question if I would be here today. That was the moment I knew I could never let this happen again. This wasn't the first time. On March 28, 2024, while I was 8 months pregnant, Eric strangled me during another violent outburst. That night, he also smashed my phone onto the tile floor. His anger has put me and my children in danger more times than I can count. Since that night in November, I moved out, taking my children with me. I have been supporting them all on my own. Eric contributes only half of daycare costs. For a short time, he offered slightly more toward my weekly daycare expenses, but not for long. In that last 7 months, the only other support I have got is about $100 beyond that, forcing me to bear the financial strain on top of everything else. His aggression has not stopped. Just last month, he got into another altercation at work. Before that, he was fired for harassing a coworker over the course of 2 years. His actions show a pattern. One thing does not start or stop with me. I am not at all the first person that has called or he has been here for. Yet, despite the danger he poses, his charges have been drastically reduced from his original arraignment, even though the court initially ruled that he was a danger to the community. I am not the first woman he has hurt, and yet the leniency of his sentencing recommendation is exactly why women stay silent, why they fear leaving, why they hesitate to come forward, because too often abusers walk away with little consequence. This is more than just my story. This is about accountability. This is about setting a precedent that says violence like this will not be excused or dismissed. This is about protecting the next woman, or the mother, and the next child from enduring what I did. I ask the court to recognize the full weight of this case, the physical harm, emotional trauma, the financial hardship, and the lasting fear. These things do not disappear once the courtroom empties. My children deserve safety, I deserve peace, and justice should reflect the reality of what happened. I would like to see jail time in his sentencing. Thank you.
Thank you. Ms. Goodrich, any recommendations from the people?
Yes, Your Honor. The defendant is 43 years old. He has no prior felonies and 1 prior misdemeanor. He's employed with a high school diploma. As the victim, Ms. Guyire, has stated as to what occurred on November 27, 2024, I know that the court is trauma informed and realizes that a strangulation the next time around the domestic violence wheel can often lead to death. He does have a prior 2008 domestic violence incident. He received 6 months probation there. There were some red flags in the PSI briefly addressed by Mr. Clayhoom that he still blames the victim, that despite the positive reports from counseling during that interview, at least he downplayed the offense. He had a 2017 case, domestic violence case that was dismissed. And here we are in 2024, and this time it went from interfering with electronic communication and domestic violence in 2008 to now 2024, felonious assault with a child abuse fourth due to the child being present and dropped based on the victim being choked. I do recommend some jail time, as Mr. Clayton stated that I would, because deterrence and due to the deterrence and punitive nature of sentencing, and would ask that the no contact remain in place.
All right, thank you. Mr. Guyire, if you please stand for the court sentence. Mr. Guyire, you're 43 years of age. You have no prior felony convictions. You have 1 prior misdemeanor from a domestic violence incident back in 2008, where it was a plea to attempted interfering with electronic communications. Your attorney outlined some of the mitigating factors of after the fact and the rehabilitative efforts that you've made. And the prosecuting attorney has outlined some of the aggravating factors that led up to and included this incident. And so this court's got to balance, the truth of both sides of that for what's an appropriate sentence here. And, when I look at this history, I mean, you've got, you've got 2 prior arrests for domestic violence. One resulted in a conviction, one was dismissed. I don't really know anything about that, so I can't completely assume that, you committed some wrongdoing there, but I've been involved in the justice system long enough to know that there's lots of reasons why those are dismissed, and it's not always because the defendant didn't do anything wrong. In fact, for domestic violence, I'll tell you, it's not often that way. And what you need to know is this: most men make it their whole lives, Mr. Guyire, and never once get arrested for laying hands on a woman. It's not that hard to take that path. Yet you have repeatedly taken a different path. The prosecutor's right that there's an escalation here from a 2008 domestic violence to now one that did involve, even by your own admission, grabbing someone by the neck. That's a troubling escalation. That's not even the most troubling thing to my mind, that you're doing that while the victim is holding your vulnerable child. It seems that alcohol has played some role in your lack of governing yourself. And you're kind of shaking your head no, but I mean, was alcohol even involved in this incident? Okay. Okay, well then, clear-minded, realizing that, I mean, I hope at some level you're experiencing some sense of shame at that conduct. Really, who does that? Grabs their wife by the neck while she's holding your infant. In the prior cases, even the one that resulted in a conviction, you were given probation. So it looks like you never really did any jail. If everything that Mr. Clayton has said today is, he's doing a great job for you, of course, and everything he's saying today would certainly cause me to follow every drop of his recommendations if I was the judge back in 2008 looking at a first-time domestic violence offender. But this is not your first time of domestic violence. And this was in the world of the domestic violence cases we see, none of them are acceptable. Some of them involve a shove, even a threatened striking someone, but not actually striking them constitutes a domestic assault. So when I think about the continuum of a domestic assault, this is more on the extreme end of it. There's certainly, I'm not overstating that, there's certainly, to be sure, more extreme domestic violences that we sadly see where there are injuries and broken bones and all sorts of horrific things. But I just say that to place it in context that this was a serious event. And the fact that you placed a child at risk of harm is a significant aggravating factor that I don't even think, honestly, I'm not looking to do this, but honestly, the guidelines wouldn't adequately take into account. It just takes into account that, somebody was placed at risk of harm. But the degree that a young, vulnerable child was placed at risk of harm aren't even taken into account there. So when I try to balance what's a proportionate sentence here, I think a term of probation to make sure you follow through on these rehabilitative efforts is appropriate. So I am going to place you on probation for 2 years, subject to the terms and conditions listed on pages 2 and 3. I want to highlight some of those conditions. You have to complete the mental health, domestic violence, batter intervention, or other recommended treatment as recommended by your supervising agent. You may not have any contact whatsoever with Ms. Guyire, consistent with the details of that term laid out in the pre-sentence report. As you guys navigate through a divorce and parenting issues, you know, perhaps there can be some way that that can change down the road while you're on probation. I don't know. But for right now, that's what she wants, and that certainly is appropriate. So we're going to make that a condition. You have to seek and maintain full-time legitimate employment. There's a crime victims assessment of $130. That's fine. You can remain seated. There's a crime victims assessment of $130. Court costs of $350. State costs of $118. You have to comply with DNA testing and pay a $60 fee. There's also a monthly supervision fee to the Department of Corrections. And I do think that some jail is appropriate, even though it's an intermediate sanction. The prior domestic violence conviction and the risk of harm to the infant are reasonable grounds for jail, despite the fact the guidelines are intermediate jail sanction. When I consider how much jail is necessary, you know, I can make a good pitch for the 9. I could make an easy pitch for 6 months if I'm only thinking about, say, deterrence toward others. But I also have to take into account the efforts that you did make, your lack of prior record, your lack of prior incarceration, so that I don't think an extreme amount of jail is necessary to kind of give you a shake by the collar and wake up call. And so I am going to order that you serve 3 months in the Sheboygan County Jail with credit for 6 months, credit for 6 days previously served. Within 24 hours of your release, you have to contact your supervising agent. I would indicate that I have no objection to your participation in any CBT programming in the jail, any counseling programs in the jail, and you can earn a little bit off your sentence in that regard as well. And Mr. Guyire, you can file an application for leave to appeal if you wish to challenge your conviction or my sentence or both. If you wanted a lawyer appointed and qualified, you'd have to make that request within 6 months. We're going to hand you a piece of paper about the appellate rights, ask you to initial 1 copy for us, and the other one is for you to fill out if you want to take an appeal. Do you have any questions for me, sir? Okay, good luck to you.
John,
Yes.
The program the court authorized him to do, does that include any kind of work release programming, or?
It doesn't. Is he employed right now?
Yes.
Okay, I would also indicate that work release for 40-hour work week would be allowed. So you'd have to work that out with the jail administrator, whether you're eligible for that program based on the offense, that you have to get them your schedule and documentation, and they have to approve you. But I'll indicate that the court has no objection.
Okay.
Mr. Clem, does that include your matters?
It does.
Okay, you have good.
Good night.
iPhone.
No problem. Is that him? Is that him? You're with Colby, Washington?
Mhm.
Okay. Mr. Johnson is your attorney, right?
Yes, sir.
Have you talked to him today? That comes in handy.
Good.
He's your guidance. You're in the woods. It's like you're lost in the woods. He's your guide. He's going to help you navigate you through the woods. So you need to get with him. This is important. You are looking at, let's see, 4 cases which carry with them up to 70 years in prison. So if you're normal, you're going to be serious about this. So y'all converse and tell me what we're going to do, what direction we're going to head in. Okay, thank you. And you're ready. Yes, sir.
$1 million bonds.
Mm-hmm. There's an aggravated assault. He's got
That should be over 50,000.
He's got aggravated assault and a murder, but the aggravated assault is a little less than that.
Yes, sir, but I thought I saw where it was
We've
like,
got 2 cases called now, 23 CR 1222 and 23 CR 951. Both the state of Texas versus Jeremy Dixon. Mr. Dixon? Yeah, present with your attorney, Mr. Vasquez, and the state's attorney. All right, the court has reviewed these files and recalls these cases. Go ahead, Mr. Vasquez.
Your Honor, it's a $1 million bond on a murder is the one most concerned with, and we'd ask for the bond to be lowered to $150,000, giving Mr. Dixon a chance to bond out. I've spoken with family members, but none of them are here to testify. I'm hoping they can pool the resources and come up with enough money to sign a contract to give to Mr. Dixon out. They've spoken to some bondmen, and he could get out and work until his trial date, and maybe hire a lawyer of his own choosing.
How would that work? Well, he hadn't hired one yet, right?
No, sir.
Well, he says he has 0 income. This was back on October 23 when he was arrested about 2 months after the murder case was filed. And he claimed 0 income at that. That's my writing. I wrote it. 0 income according to the defendant. I was on what's changed.
Your Honor.
Wait a second. What's changed? You know? I mean, he's been in jail. So how can he hire somebody if he has 0 income?
Well, Judge, I don't want to misrepresent anything to the court. I'm thinking, or it's been indicated to me that the family members will try and raise him.
What's stopping them from doing that right now?
I don't know.
What else do you want to add? Because I've got some things on the record.
That's all I have.
Anything from the state?
Just that the nature of these 2 cases, that the timeline in which they occurred makes it very clear to me that the bond is sufficient and should not be lowered.
Okay, anything you want to say?
Yes, at the time, October 2nd.
Of what year?
23. I was already incarcerated August 6th. I was arrested August 6th when I lost my job because of my arrest.
Okay. Have you been in custody ever since?
Ever since.
Yeah. Okay. So where would your income come from if you were released?
Work.
What work? What work do you have?
Well, my family has a mechanic shop.
Oh, okay. Are you good at it?
Yes, sir.
Okay. Well, how much do you get? How much do you get paid? How long did you work with them?
Well, all my life.
All your life? Oh, okay. And you are right now what? 35. Okay. And you've been working for them. You've made a good income?
Yes, sir.
Since how long were you working for? Like when you turned 18 or something?
Yeah.
And so about 16 or 17 years? Okay. So how much is it that you made?
I go by commission.
Sir?
You go by commission.
Okay,
50%.
whatever. How much income did you have annually about?
Oh, 50,000 a year.
50,000 a year?
60.
That's pretty good. I want you to send me all your income tax returns so that I can verify that. And those are on file. Get them to me so I can look at them, okay?
I haven't filed taxes since 2021.
Get the ones you had before. Get all the tax returns that you have filed. You can get those from the IRS, copies of them. You ought to have copies.
Yeah.
Get those so I can verify that you really had an income like that.
Yeah, and I worked side jobs too.
That should be on your income tax return.
Yeah, it's all on them.
Good. Then get them to me. Get copies to me. Do you understand?
I don't.
That's the first thing. The next thing is the record's going to show a couple of things. Number one, this 23 CR 951 is the first event. And this alleges that on July 2nd, 2023, you were charged with that you committed aggravated assault with a deadly weapon, a second-degree felony, with the use of a deadly weapon, namely an automobile. And that was indicted, looks like 3 weeks or so after the event. The grand jury got on that pretty quickly. When were you arrested on that case? Do you remember?
I wasn't.
You never were?
Never.
There was a warrant issued on that date, a capias for you.
Well, I was told the warrant was issued August 9th, after I was already arrested.
It was issued the day it was handed up by the grand jury on July 26th.
And I was also told that that indictment was about hearsay and allegations.
Don't talk about that.
But the grand jury indicted you. That's all that's important. The grand jury indicted you. They have evidence, probable cause you committed a crime, period. That's the way indictments work. It's not a debate on what the evidence was, but they handed it up. You're going to interrupt me?
So
No, yeah. You're in trouble. You're in a lot of trouble. The worst thing is to be rude. You get the chance to speak, but don't interrupt me. It seems like that's what you do, is try to control the environment you're in. We all have a fair opportunity. Don't step on me when I'm speaking. She has to take down everything that's said. When we both speak over each other, she can't do it. When she can't do that job, the Court of Criminal Appeals, the highest court, gets upset with somebody because they say, we want to review what goes on in the courtrooms. But when everybody's speaking over each other, the court reporter can't do her job. So someone gets in trouble. It's going to be you, not me. Do you understand? Don't speak over me. That's what we learned that in first grade. Don't interrupt. You'll get a fair chance to be heard. Okay, so we have an indictment and a warrant pending on July 2nd of 2023. Then on August 6th of 2023, what's that? A month, a little over a month later, it is alleged you committed the first-degree felony of murder. Then a warrant comes out on that because that's indicted on August 23rd. So they indicted you about 2 weeks after this. So there are two warrants. What was the date he was arrested? And each of these involve
Day of the murder, Judge.
Okay. Each of these allege you committed violent crimes and used a deadly weapon in each case. So those work against you. When it's an aggravated crime, when there's two aggravated crimes, you get double trouble. So what are his bonds on each of these?
50,000. And 1 million on the murder.
And this first aggravated assault, it was alleged that you drove over a human with your automobile, and they were injured because of that. The other motive, you used a firearm in the killing of another human being. Okay. The other seven. Case criminal history here. About criminal history, Mr. Vasquez, anything you want to comment on? Because that's one of the factors in setting a bond is the circumstances of the crime. And in this case, 2 violent crimes committed within a few weeks of each other. And even aggravating offenses that are from an aggravated assault next to a murder. The court is reviewing a criminal history data. And what do y'all want? Anything you want to say? Because it's 4. Well, the criminal history is 4. Looks like the defendant was placed on deferred or unadjudicated probation on 2 cases in 2010, illegal possession of controlled substance and a theft.
That's correct, Judge.
Did he satisfactorily serve those probations?
As far as we know.
Then in 2013, he was convicted of failing to identify. That's a misdemeanor, isn't it?
Yes, sir.
And then also convicted in 2017 for eluding or fleeing a police officer. What happened on those 2 cases, please? On the controlled substance and the theft, there's F as in Frank 98069 and F as in Frank 10-9188. He was placed on deferred or unadjudicated probation on August 23rd of 2010. Did you serve those out satisfactorily? How long were those deferred? How long was the deferred? Does it show?
I believe it was 5 years.
But he's convicted in 2013 of failing to identify. I guess they didn't revoke him for that.
Yeah, that's a little.
You know anything about that?
I don't.
I think he's acting like he knows.
What? Yes.
I was let off early on probation.
Oh, they dismissed it early?
Yes.
Okay.
Well, the 09.
You can get it off. You can get dismissed in a third if you do well. A third of it. So what's a third of 5? 1 2/3. 1 2/3 years. So you're on deferred, and then 3 years later, you're charged with failing to identify so your probations could have ended then. Before
MTRP was filed.
Ma'am?
But an MTRP was filed.
On which case?
The 09-8069.
Yeah, the controlled substance.
But then they did early dismiss his probation in 2013, February of 2013.
What happened in the motion to revoke
So
probation?
I'm assuming it was recalled. In the images.
Okay. All right.
Judge, I will also point out to the court, that's not going to be in that criminal history because it was run when this was indicted. But he has a 2023 offense of discharging a firearm in a municipality that he pled to while he's been in jail.
Okay, it's a class A misdemeanor, isn't it?
Yes, sir.
Okay.
But both on together on probation, so both were dismissed on January 20th.
Do you have a driver's license? Did you have a driver's license? An active, valid one?
Yes, sir.
It was not taken away? It wasn't? You certain?
Yes, sir.
Do you know how many traffic violations that you were charged with between 2019? I'm sorry, between 2007 and 2019? That'd be 12 years. Do you know how many? Yes. I mean, it's your life, you know, but I'm looking at it.
I mean, I don't know how many, but
About how many?
And tickets on.
About how many tickets would you say you got?
I spent $7,300 worth of tickets.
$7,300? No. How many separate offenses of operating motor vehicle irresponsible? About how many? You know, it's your life. I know how many I've gotten. Yes.
Don't know.
Well, about when? About how many?
I don't know.
38. 38. That's
That was from the affected part.
yeah, tickets, and also these are misdemeanors, but it's a whole bunch of them. Plus theft, disorderly conduct, illegal possessions. No, there's a cluster of state jails between charges in 2009, 10, and 11. Anyway, the problem is that for someone, you know, as you from youth, you have been consistent in committing crimes, and these are just getting worse. We go from traffic violations, which are Class C misdemeanors, and now you've got a first-degree felony of a murder, and aggravated assault, a second-degree felony, all within a month of each other. You pick up these, and so the aggravated nature of each of these crimes are most disturbing, and then your criminal history has gone from numerous Class C misdemeanors to now first-degree felonies. And the circumstances of the crime in each case are severe. Your criminal history, even though you're not loaded with a lot of felony convictions, it has been a consistent pattern of irresponsibility in failing to follow the rules. All right, anything else?
No, sir.
Anybody want to add anything?
No.
The court finds that the bonds are sufficient in their amount because the reasons for bonds to be set based upon the circumstances of the crime, in this case, 2 separate serious violent crimes, including a most serious murder, and those are worthy of high bonds to not only show the seriousness of these crimes, but to protect the communities from further criminality of the defendant. Now, we're set for trial coming up, right?
Yes, sir.
Okay, we tried to get it last time, but this is on our radar. So are we going to try the murder or both at the same time?
Just the murder.
Right.
I plan to offer extraneous evidence of the other.
All right, anything else, Joe?
No.
All right, that is all. Thank you. Next, we got. Y'all getting closer? Good.
Thank you, sir.
Yes, sir. On Daniel Raleigh. Mr. Raleigh, have you talked to Tom Burbank today? He's your attorney, right?
Correct, sir.
Can you call him up and find out where he is? He's 45 minutes late. We hadn't gotten a call or anything from him.
He just texted. He said it's Hardin County.
Hold on.
I said, in his office just texted.
He's in Hardin County. Why he's in Hardin County, no one knows, but He should be here.
So I'm hoping to find out.
All right, we'll have to wait. Stand by. We're not going to Hardin County. He's got to come up to us. What do you have, Kevin?
I have a plea in Mr. Smallwood's.
Come on up.
Well,
I don't have it signed yet, Judge.
Oh, okay. Okay, it's fine.
She up here.
Mr. Smallwood. Yes, you're gonna have to get a thumbprint with her in a minute. Yeah, stand by. They're fixing the papers. They'll just take a couple minutes. Thank you. Sorry about that, Sonny.
Yeah, I can do it now. You go, man.
You're gonna get.
Straight up and down.
Milton, who was called earlier from Docket is here now. Okay.
Same phone.
We get from the lesser included.
This is
Class A, so.
straight up there.
He's covering my. And he's a veteran.
She was yesterday. I had it today. She was on forfeiture.
Okay, who's her attorney?
It's Don, but because of Jim and Dave wrong, I couldn't get Don here today, that she needed to appear.
What's sorry?
It's initial vetting to double check.
Can I you get the file? Is that it? Thank you. So there are two cases?
Yes, sir. I'll find the file.
Mr. Smallwood, just wondering if you were asking.
No, I was looking at Miss Milton's.
Two copies.
Can you? Oh, mm-hmm. Yeah.
I think it's in town. Finding a residence.
Judge, this is a plea on the lesser included.
Yeah, I'm looking at this lady right here. From probation, we're gonna need some help. Yeah. Okay, on Brandon Smallwood. Yes, sir. Mr. Smallwood. Okay, we now call 25 CR 505, the state of Texas versus Brandon Smallwood, who is present with Mr. Lane, his attorney, and the state's attorney. The defendant is charged in an indictment here with the third-degree felony of assault of hospital personnel on hospital property. And let me see, there is an plea agreement. Let me look at it real quick where we're headed on this. I say misdemeanor of assault. Right?
Yes, sir.
Okay. So the defendant is going to be pleading to the lesser included Class A misdemeanor of assault, which is within the wording of the indictment where it is alleged the defendant intentionally, knowingly, and recklessly caused bodily injury to another person.
Yes, sir.
And because we're dropping who the personnel and employee who was the victim, who has special protection under rule of law because of their job, that would have enhanced it to a third-degree felony. So you're going to be proceeding on the lesser included Class A misdemeanor of assault, which carries with it up to 1 year in the county jail and or a fine up to $4,000. Do you understand what you're facing, sir? Yes, sir. An agreement has been reached in your case that you would be placed on deferred or unadjudicated probation, which can be up to 2 years in length, right?
Can be, Judge.
And Was there any restitution here?
No, sir.
It's up to the court's decision on the length of probation, but it would be deferred or unadjudicated probation where you would not be found guilty so long as you followed the conditions and terms of probation. If you failed, your probation could be revoked. You could then be found guilty and sentenced up to 1 year in jail. Do you understand?
Yes, sir. And just in light of that, Your Honor, Mr. Smallwood, he is a disabled veteran with he's schizophrenic, disabled veteran.
Is he competent?
Yes,
He wasn't acting insane at the time. He's not insane at the time.
Absolutely not.
Okay.
No.
Well, it's
I feel that the judge is going to do something beyond our agreement. That's all.
like what?
Like make the term 2 years instead of 1 year deferred.
Well, that's what I can do.
So you're arguing. I'm just trying to convince you.
But I can also shorten it.
Yes, Your Honor.
For good behavior on probation.
We have no objection to that.
Yeah, which I do it literally every day.
I know.
Every day. No. Just
This was at Baptist Behavioral Judge.
I understand. And what I want to do in making rulings like this is the rights of the defendant are foremost because it's constitutional. On the other side of the coin, we have victims who feel like when you're caring for people who are sick, that's a most wondrous profession. We don't want people to say, I don't need this anymore if I'm going to get kicked in the face.
I agree.
Like what happened here. And they're going to know from what I do that they're protected as victims and you're going to be held accountable fairly. But, they don't get paid to get punched or in this, I'm sorry, this was kicked on the right side of their face, causing them pain. They're doing you a favor. They're taking care of you. It's a most wondrous profession. I don't want people going, I don't need this because I'm not protected. All right. You have to pay. And these are wonderful professions. And the people need to be taken care of. Well, I'm going to follow the agreement, but they're going to know, you're going to be put on probation for 2 years. You do well, I'll shorten it as a reward. Okay. And we can do it in a third of the time.
Thank you. Do you understand? No.
Just don't do this, please. Don't hurt people, especially people who are doing God's work by helping other humans and trying to care for them. And if people said, we're not going to do this job, we're not going to do this because people kick us in the face, then what happens when you have to go to the hospital? Nobody's there to care for you. All right. If I follow this agreement, which is placing you on deferred or unadjudicated probation, and again, there's no restitution here, correct?
That's correct, Judge.
And this can be up to 2 years in length. If I follow this, sir, which I intend to do, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this lesser included Class A misdemeanor of assault? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I'm going to show you here what's marked in State's Exhibit 1. Did you sign that document?
Thanks.
Voluntarily? Did you understand it? Discuss it with your attorney? Or the contents all true and correct?
So,
State's Exhibit 1 is tendered into evidence.
no objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. The indictment's been read to you, or you've read it. You are guilty of the crime charged and any lesser included offenses like the one you're pleading guilty to, the lesser included Class A misdemeanor of assault. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. State's Exhibit 1 is made a part of the record for all purposes.
No objection.
Pre-sentence report is waived.
It is, Your Honor.
I'm going to follow this agreement, and on a 2-year, if he's placed on 2 years probation, we can shorten it to 1/3 of that too, right? Which is 8 months.
Yes, sir.
What I want though is also on this probation, we've got to take care of certain things that put him in this situation. Do you take regular medicine or something?
Sir.
You do?
Yes, sir.
Okay, you're going to have to continue to take the prescribed medication as it is prescribed. Don't fail to do that.
Yes, sir.
Was that a problem here in this case? Did you fail to take the medicine on time or something? Maybe, I don't know.
He went in to the hospital for an episode, a mental episode, and I think this all kind of sprung out.
Okay, what about is there a program for folks who have, we need to know what it is for his mental issues that he is being handled with so that we can make sure that he continues and maintains whatever assistance he's getting.
That would be the mental health caseload, Judge.
I think she.
Okay, he's on there. We'll put him on there. Okay, good. That ought to take care of it.
Yes, sir.
But take all your medicine and make sure. Now, what happened? You get this from the military?
Yes, sir.
Were you affected? What were you doing? Were you in? Where did you go?
So Kuwait.
Kuwait.
Yes, sir.
Okay. And were you injured there?
Yes, injured.
Yes, sir. But it wasn't a friendly place, was it?
No, sir.
That was very dangerous. Yes, sir.
I scan people in with the wine and stuff like that.
Sir.
I scan people in with the wine, look for camera and stuff like that.
Yes, sir. But this medicine that you're taking helps you, doesn't it?
Yes, sir.
But you got to
Stay consistent.
keep doing that as prescribed. That's going to be important for your probation.
Yes, sir.
It helps you be the best you can be. Okay. I think it's in his best interest that we do as long as we can just to help him. Because we don't want him to backslide. All right. I'm going to follow this agreement and find there is sufficient evidence supporting this agreement from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt as you are mentally competent to enter your guilty plea and it's freely and voluntarily made. But to find you guilty beyond a reasonable doubt, there's enough evidence here, but I'm not going to find you guilty.
Yes, sir.
So long as you follow these terms and conditions of probation, you get another chance.
Yes, sir.
It'll be for 2 years or less, and there will be terms and conditions of probation which are normal and customary for this type of situation, including you will be completing an anger management class and also be placed on the mental health caseload. And also it goes without saying, God bless you, whatever you've been prescribed for medicine or for your medical needs, you must follow those prescription requirements and take your medicine as required. Okay. And then everything should be fine. Okay. You're going to be released here. And what are you going to do next? Do you work somewhere?
Sure.
Are you looking for something for employment?
Currently work disability and SSDI.
He's married, Your Honor. I've been in pretty constant contact with his wife. They were in Florida.
Living? Is that right?
I believe, yes. And
they're back?
Yes. So I think they're going to have to establish another residence. And I've told them they'll have monthly reporting duties to Jefferson County and to wherever they're going to go permanently.
Okay. Does your wife work? Is she employed? Nobody's employed in the house?
It's all I just received a disability.
Yes, sir. I understand, but I know a lot of people who are disabled who are, employed and do things.
I would like to work.
You would? Good. Well, don't think you can't do it. If you're capable and you want to do it, you can do anything you want. As long as it's following the rules and not hurting others. But working helps the world and helps you. It makes the world a better place by you getting involved and doing good things. And then getting paid for it. Things you like. Okay. All right. But anyway, work with your probation officer. They're very nice people and they'll help you along. Good luck. Yes, sir. Okay. Take that medicine in. Like you're supposed to. Okay. Thanks, Mr. Smallwood. Kevin, anything else on this?
No, Your Honor, thank you.
Okay.
The process of getting bail.
Yeah.
Person, right?
Your cat.
So they're only going to
What are we doing today? Got to work on this a while. What are you asking?
I think we can send it too short there. I think we've been coming back here. We get 30 days. Hey, do you agree to 30? Because we've been sending it. Yeah. We'll meet you the next week here. By the time we get through our week, we haven't got a chance to maybe hash things out there.
Okay.
Judge, he's
Mr. Bell?
Yes, sir. DA board is looking for justice like me, and it's taking us. We're both searching for justice here, Judge.
When you find it, let me know.
I will.
Melissa? Bella? Okay. All right, how much time do you want reset on this?
Well, maybe 60 days, Your Honor. That would give us time. There's a co-defendant that we're more concerned about getting that resolved first.
Okay, reset 2 months. Do it. Perfect. Stay out of trouble, right? Okay, all right. You're looking at up to 20 years in prison here. That's serious. Deal with it seriously and make Mr. Cole here, great lawyer. You're like lost in the woods now. He's your guide. He's going to guide you out of the woods. Follow his advice. He's a responsible man.
She has a baby, you know. She has a baby.
Yeah. Well, what are you telling me that for? I got my own grandchildren.
I know, right?
Yeah,
This is not good news for you. Come on up. You tested positive for marijuana. What are your bonds in these cases? All right. In 23 CR 905 and 907, ma'am, as you know, you are charged with the state jail felonies of forgery and fraudulent use of identifying information. And these are state jail felonies which carry with it up to 2 years in the state jail on each case. On your bonds, the first bond condition is do not commit a crime. That's the first bond condition of everybody's conditions on bond. You have tested positive for THC, tetrahydrocannabinol, marijuana. You have marijuana in your system. Thus, that is a crime of illegal possession of drugs. Her bonds are what?
10,000.
They are revoked. Now they are doubled to $20,000 each. Plus, you must have a drug patch as a condition of bond so that we will be testing you constantly to make sure that you don't fall on the bad side and continue to make mistakes here. You're looking at up to 4 years in confinement on these two cases. You've got to deal with these responsibly. And this is not responsible behavior by failing to follow your bond conditions. And most certainly, you have to avoid drugs. That's crazy. We will tell Mr. Dusler about this. I want this set here. Can you, we have a docket tomorrow? Is that correct or not? Yeah. All right. I'm gonna add it tomorrow because I'm looking at these cases and the circumstances, and she admits
And that was
she admits to the crime.
That was supposed to be an affidavit because the situation was.
There were two co-defendants. One of them admitted it, and then at the last minute said that it was her idea.
Trying to look
I spoke to Milton on February 10th. I spoke.
She was the one.
Yeah, but no, this isn't a debate. I'm going to read to you what the problem.
Thing was it on the paper, but I'm telling you,
You're going to interrupt me?
No, I'm not.
You're taken into custody. You're going to interrupt me? That's not the way to handle it responsibly. That's not the way. This isn't a debate. Hold on. The probable cause affidavit signed by the officer states he spoke with you on February 10th. You provided a voluntary statement saying you're the one that picked up the identification cards outside of the gym and had the check in your possession. When confronted with the fact that the driver, the other person, confessed to signing the check, you told the policeman, told the officer, the driver only did that to protect you. So you admitted, you confessed to this crime. Now, the other one did too, but you were insisting she was wrong. She was covering for you. That's your fault. So that's what you're stuck with. That doesn't look good. But there's a responsible way to handle this. Everybody makes mistakes who are in this room, who come in. Just fix the mistake properly. Be responsible. There are proper ways of handling it. And number one is work with your attorney. But number two is don't commit crimes while you're on bond. Don't ever commit a crime, but being around drugs, even if you're around them, you need to run. If it's marijuana, you know what it smells like, you run away because you are required. You can be tested at any time under the eyes, all people on the bonds. Why you'd even get around it in the situation you're in is flirting with trouble. But we're going to put you back on the docket tomorrow to bring you up and see if get Mr. Dusler up here to talk to you about how this might be something that can be disposed of in your best interests. Okay, that's what we want to do. But you got to be honest and follow the rules. And those are the same things I got to do. And that's the way you fix a mistake. Everybody makes a mistake. Me, you, we all do. It's how you deal with it. That's really the test of your character. Are you a good person? Then deal with it responsibly. Fix this. This is fixable. And that's why I'm bringing this thing back up tomorrow, that it might be able to get fixed tomorrow. Now, do you have private stuff that you need to get to your family or something? Because you're under arrest until you can post this bond and get a drug charge. And that's why it's going to probably not be tomorrow. That's why we're going to bring you back tomorrow. Yes, ma'am. Yes. Oh, yeah. I'm not letting you out when you have drugs in your system. I'm not letting you walk out of here.
Well, no.
You get work. The bailiffs are good people. They'll take care of all of that with you. But you've got to you're stuck here.
So
you've got to act more responsibly.
So tomorrow, then you guys.
We're going to bring you back tomorrow morning and hopefully try to resolve this. Thank you. Now we're with Mr. Rowland, and let's see how we can try to get your lawyer here.
All right, and we are continuing on the record in the 53rd Circuit Court for the County of Sheboygan and providing public access now, both in the courtroom and also online. And we have on our afternoon docket then, People versus Jerry Jones, file 25-7023. Counsel, you want to state your appearances for the record?
Also, Goodrich, Warren County Prosecutor.
Luke Gusky on behalf of Mr. Jones, Your Honor.
All right, good afternoon. This is the time and date set for a docket call, and also there's a show cause. Mr. Jones, it's alleged that you're in contempt of court for violating a condition of your bond. You have the right to have a hearing on that allegation where your contempt would need to be proven beyond a reasonable doubt. And you have the right to the assistance of your lawyer at that hearing to present evidence in your own defense and question any witnesses presented against you. If I do find you to be in contempt, I could jail you for up to 93 days or fine you up to $7,500 or both. If I believe that you're not complying with the conditions of your bond, I can revoke or amend that bond at any time as well. Do you understand the rights you have and the penalties that are involved?
Yes, Your Honor.
And Mr. Kukuski, do you know how Mr. Jones wishes to proceed on that?
We'd ask for a hearing at this time, Your Honor.
Okay. And where are we at on the underlying case on the docket?
Now, although we've had some fruitful discussions, we're not resolved. So I'd ask for the court for possibly another docket call in regards to the matter.
Any objections?
No objection.
What about July 22nd at 1:20? That work? We'll set it for a docket call.
Yeah, that should work.
And we'll set it also for a status conference on the pending violation. When I reviewed the complaint, I think the prosecutor wanted it brought forward and addressed. It seems to me that, Ms. Goodrich, am I misunderstanding the situation if I'm under the belief that this was a fairly technical violation without any harm?
That is correct, Your Honor.
Okay.
And it sounds like from talking to Mr. Kukuski that he has taken that seriously and even didn't go to the last All-Star game. So I would not be asking that bond be revoked or anything today.
Okay. So what I'm going to do is we'll continue this docket call and a status conference on the pending violation to July 22nd at 1:20 in the afternoon. I'm not going to revoke your bond on the pending violation. It does sound like it was a fairly technical matter, but you know, those technicalities are important in a case like this, and it's important that you follow them and work with your attorney to make sure you're in compliance. It would be my intention to just kind of track this as a status, and if there's no further problems in this area, then this one is not going to turn out to be a problem for you. Okay? But you want to make sure in these kinds of cases, especially if it comes to my attention that there's a violation involving contact that I find concerning at all,
Yes, sir.
I won't do it as a show cause. It'll be a warrant and you'll sit in jail.
Absolutely.
Okay. All right, we'll see you then, sir.
Thank you, Your Honor.
Thank you.
All right, let's go back on the records and we'll call next case is People versus Windom Reager. It's file 24-6853FH. Counsel, want to state your appearances, please?
Melissa Goodrich, Wayne County Prosecutor.
Luke Gusky on behalf of Mr. Reager, Your Honor.
All right, we're here for sentencing on a charge of operating while intoxicated, third offense, a 5-year statutory maximum. Guidelines were initially scored at 0 to 9 months. Have you had a chance to review the pre-sentence report and recommendations with your client?
Your Honor, I've had a chance to review the report recommendations. We didn't have any objection to the report recommendations and no scoring challenges at this time, Your Honor.
You, Ms. Goodrich, any additions, corrections, or scoring challenges from the people?
No, Your Honor.
And I would note, I also did have an opportunity to review, I didn't count them, but there were probably in excess of a dozen letters of support, predominantly from the AA community, as well as documentation of AA attendance on behalf of Mr. Reager. Thank you for forwarding that, Mr. Kukuski.
Thank you, Your Honor.
And anything you want to say on behalf of your client?
There is, Your Honor, and just briefly, Mr. Reager finds himself in a sad situation here, being he's operating on intoxicated third offense. He was a successfully completed sobriety court just a few years ago, relapsed in this case, and here we are. What he's done since this case and since he's been pending the pendency of this, I guess, sentencing in this case, is he's started a Al-Anon meeting here in Sheboygan. He's brought that back. The community did not have one, and the AA community saw a need for it. Mr. Windom stood up and started a meeting, and he's passed it on to a friend of his, and they've been co-chairing that meeting, but he's been the one that started it and got it going. He attends AA very regularly, almost religiously, Your Honor. He's been very dedicated to sobriety. He understands this relapse and the situation he finds himself in is very unfortunate. He's got all the nice letters that Your Honor's had a chance to review. He's had this overlink on since this offense occurred, and this offense occurred back over a year ago, April of the year. So he's not had any issues on his bond for well over a year. He started new meetings here for the Al-Anon community. He's been attending AA religiously. He's been still counseling. He's got great employment. He's got his business all tied up and wrapped up so that it can be taken care of while he's incarcerated. All those reasons, Your Honor, I think set Windom apart from your normal drunk driving third offender that you see in front of the court. I'm not sure I've had a client that has amassed the AA attendance, the letters, and the credentials that Mr. Reager has. And albeit he's still on that path for sobriety, and he's still moving forward in that direction and moving forward in the right direction, Your Honor. So I'd ask the court, the recommendation and the agreement was not to exceed the midpoint of a guideline range. The guidelines were 0 to 9. The recommendation here is just the 30 days. I'd ask the court to adopt that recommendation, just setting Mr. Reager to the statutory minimum 30 days. So he can get back out and continue to provide a service to this community that is desperately needed with the AA community, the Al-Anon, and all that good stuff that he's doing, Your Honor. I'd ask the court not to overlook that because this is his third offense. Thank you.
Thank you, Mr. Contestant. Mr. Reager, it's not required that you would say anything today. You don't have to, and if you don't, I don't hold that against you. You are also allowed to say anything you wish. Is there any statement you want to make, sir?
No, Luke said it pretty well. I'll leave it at that. Thank you.
Okay, very good. Ms. Goodrich, any recommendations from the people?
Yes, Your Honor, thank you. The defendant is 60 years old with no prior felonies, 4 prior misdemeanors. He's self-employed with a high school diploma and 3 years of college. We're here because on April 10th of 2024, the defendant was viewed crossing the center line, having difficulty navigating curves. He did admit to consuming at least 4 beers. His blood test came back a 0.214, more than double the legal limit. The PSI recommendation is for 30 days. When looking at Mr. Reager's history, in 2007, he had an impaired in Sheboygan and received fines and costs. In 2008, he had an OWI with 2 years probation. In 2013, he had an OWI third that was reduced to a reckless and 10 days jail. In 2020, he had an OWI third reduced to an OWI second with 1 year in jail and 2 years probation. Now we're here on this new conduct from 2024. For the first time, he is a convicted felon, but I do believe that the jail time should be more than 30 days. I would recommend 3 months jail, which still would be consistent with our plea agreement for mid-guideline range. Thank you.
Okay, I'm going to assume that the year imposed in the district court matter would have been suspended when you were in recovery court. You didn't actually do a year in jail on that, right? Okay.
Sobriety.
Okay. All right, Mr. Reager, if you'd stand for the court sentence, please. All right, well, Mr. Reager, you're 60, you don't have any prior felonies, but you know, the prosecutor outlined your history with drinking and driving, and it's a very troubling history. We've got great letters from the AA community about your commitment to sobriety, and that's fantastic. And sounds like you were involved with them beforehand, and they talk about your slip or your relapse and then coming back, and that's, you know, that's fine. And I'm glad you're back involved in that. That's going to be a necessary part of your success, continuing on with that fellowship. But it's important to recognize that, you know, you are not standing in front of a judge today because you had a slip, because you had a relapse on alcohol. It's because you drove while drunk. There's no addiction that makes you drive. But for some reason, you repeatedly make decisions to drive after you've been drinking. You don't strike me as somebody that wants to do harm to other people, but you could wreck somebody's life or take somebody's life every time you do this. And what's really troubling to me is, the officers on the scene, when they pull you over and, clearly you're not driving right. And they asked you about how much alcohol you drank and you said, within my boundaries. I mean, somebody that's got 3 prior convictions and 4 prior arrests for drunk driving and has been through a sobriety court to be twice the legal limit and telling an officer when he's driving that you're within your boundaries shows to me not just a relapse, but a profound misunderstanding of the nature of your disease at that time. I hope you're in a better place now, but it's tough to figure out, what to do. The guidelines at 0 to 9, would call for an intermediate sanction, which would mean we shouldn't give any jail unless there's reasonable grounds to do so. Here, there's a mandatory minimum 30 days, so we at least have to do that. But these guidelines don't adequately take into account. They do take into account prior history. What they don't take into account is that you keep doing the same thing. And that places people at serious risk of harm. Prior probation has not been working well. You had a treatment court, and that has not been enough to keep the community safe from Windom Reager driving drunk.
Is it too late for me to say something? Or can I say
Go
something?
ahead, say something.
I said that I was an alcoholic in the past, but I didn't truly believe it until April 10th of last year, when I finally said, I am an alcoholic. And it finally clicked, that.
Well, I mean, I hope that's true. I hope that's true.
That's all I want to say.
Okay. Well, and that's consistent with, what I'm saying is that up until last April, you didn't really have an understanding of what was going on. So it's tough to know, really what to do with you because, we've tried a lot of different things. Presuming that you didn't do much jail in recovery court, it looks like the most you've done before is around a month. You have a sentence agreement for a midpoint cap. This is a true 4th conviction. There was another one where you were arrested for an OWI 3rd, pled to reckless. I don't really know a lot of the details about that, but that's a troubling driving history. So taking all those things into account, I'm going to place you on probation as recommended for 18 months, subject to the terms and conditions listed on the pre-sentence report on pages 2 and 3. They include, I want to highlight some things, obtaining a substance abuse assessment following the recommendations, a curfew, 60 days of community service, employment, court costs of $350, crime victims assessment of $130, fine of $500, $225 OUIL reimbursement, DNA testing with a $60 fee, $68 in state cost, and a monthly supervision fee. And in terms of a jail sentence, I'm going to follow the prosecutor's recommendation for 3 months in the Sheboygan County Jail with credit for 2 days previously served. I'll indicate on the judgment that I have no objection to your participating in any jail programming, including CBT or trustee status, if the jail determines you're eligible for that. That doesn't mean you get to demand those things of the jail. Sometimes when I say that, they go back to the jail and say, how come I'm not a trustee? That's just me saying, I don't veto those things. It's up to the jail administrator what programs they want you in. But if they approve you for any of those, I'm going to have pre-approved on my end.
Got it.
And that can shorten your sentence.
Does that include the work release, Your Honor?
I would not allow work release. No.
You're not allowing work release during those 3 months?
I'm not.
Okay, well, I'm done working for the rest of my life.
Well, then you're done working for the rest of your life. I don't care.
Okay.
I'm not letting you out of the jail. You're serving that time and you're lucky it's only 3 months. And you're not done working for the rest of your life. You can get out and get a job. In fact, I promise you, you're not done working for the rest of your life because a condition of your probation is that you work 30 hours a week minimum. If you don't, you'll come back and do some more jail.
I guess what I meant was.
Mr. Reager, you should consider seriously stopping talking right now. I've announced my sentence. I believe it's proportionate. It's within the guidelines. It's consistent with the plea agreement. You're eligible for early discharge from probation. If you successfully complete the terms, I'm going to hand you a piece of paper about that. If you want to appeal, you can do so. If you want a lawyer, you got to ask me within 6 months. We're going to hand you a piece of paper explaining that and ask you to initial one copy for me. The other one's for you to fill out if you wish to take an appeal. Within 24 hours of your release, you must have contact with your supervising agent. And I hope, and you should hope, that you don't come in front of me in violation of probation.
Thank you, Your Honor.
Preston, do you have any other matters?
I believe that concludes my matters, Your Honor.
All right, yep.
Thank you.
You have a good day.
You too, Your Honor. Thank you.
See, we've got Ms. Anderson and somebody on Zoom that might be Mr. Yeah. Ms. Anderson, good afternoon.
Good afternoon, Your Honor.
All right, up next, we'll call People v. Steven Palowski, file 25-7013FH. And there's a phone zooming in. I presume that might be your client there. Yep, there we go. All right, Mr. Palowski, can you hear us?
Yes, sir.
All right, this is the time and date set. It said initially on the docket arraignment, but we already did a waiver of arraignment and scheduling order. So this is up for a docket call to see if the case is resolved, if we need an additional docket call, or if we're ready to place it on a trial docket. Ms. Anderson, what's the status of this case?
Thank you, Your Honor. Mr. Palowski completed the drug court application today. I intend to send that in as soon as I'm back to my office for review. I do believe that that may be able to resolve this case if he is screened eligible. So at this point, I would ask that this be placed on another docket call within a month or so, so we can see if he is eligible and accepted into the program.
Okay, any objection, Ms. Goodrich?
No objection.
Okay, how about July 22nd? And does afternoon and I'd allow your Zoom appearance. And does, even if it is resolved and you're going to be entering a plea, if you are okay doing a plea hearing by video, I'm okay with that as well. I know you're up across. Does morning or afternoon work better for you that day?
Your Honor, morning if it's available.
Yeah, I can do that. How about July 22nd at 11:10 a.m.?
Thank you.
All right, and the status of that application, it is going into the prosecutor's office today, you said?
As soon as I return to my office, it may be after business hours for the prosecutor, but I did receive it completed to my email today. So I will send it as soon as I get back to the office.
Okay, very good. All right, thank you. Anything further from the people?
No, Your Honor.
From the defense?
No, thank you, Your Honor.
Okay, have a great day. Have a good day, Mr. Palowski.
Thanks, you too.
For a second. All right, we are back on the record, and next we've got People v. Noah Hindman, file 25-6965FC. Counsel, you want to state your stances, please?
Melissa Goodrich, Blaine County Prosecutor.
Thank you, Honorable Reverend on behalf of Mr. Hindman, who's here seated to my right.
All right, good afternoon, and we're here for docket call. I did speak with counsel at the bench prior to and was informed that Mr. Gurumurthy, there are some additional factual and legal matters you wish to explore and wanted this put out some.
Yes, Judge, if we could set this out maybe 30, 45 days. I think we looked at the August 12th date. I'm still waiting on the risk assessment for Mr. Hindman. Ms. Goodrich and I are in plea negotiations as well. Based on the offer, the lease that was tendered, that I've scored, Mr. Hindman has stopped under the guidelines of 24 months. I've discussed that with Mr. Hindman, so we're still exploring some other options in lieu of trying to resolve both his matters. There is a pending matter in district court as well. If we can resolve both matters, bind the other one up, we might be able to take care of those two issues here, Judge.
Okay, Mr. Goodrich, any objection to that timeframe?
No objection.
Okay, so we can continue the docket call then to August 12th at 1:50 in the afternoon. I would indicate Zoom appearances would be allowed for you, Mr. Gurmurthy, and you can decide what else you've got that day, if you want to be present or not. If you Zoom in, we'll just put Mr. Hindman in the Zoom room for you if you're here in person or not.
Thank you.
Anything further from the defense?
No, sir.
From the people?
No, Your Honor.
Okay, we'll see you then, Mr. Hindman. Let's go off momentarily till we get Mr. Jarman ready. All right, we're back on the record, continuing our afternoon docket. And up next, we have a sentencing in People versus Curtis Jarman, file 25-6963 FC. Counsel, you want to state your appearances, please?
Melissa Goodrich, White County Prosecutor.
Thank you, Honorable Worthy of being Mr. Jarman, who's your seat to my right.
All right, and we're here for sentencing on criminal sexual conduct, second degree, person over 17, victim under 13, 15-year maximum, and 2 counts of CSE third, 15-year maximum. The guidelines advisory are scored at 50 to 100 on the second degree and 78 to 130 on both third degrees. Mr. Gurmurthy, have you had a chance to review the report and recommendations with your client?
I did receive the report, Judge, in the sentencing information report. I reviewed that with Mr. Jarman, and I also reviewed the sentencing information report. I don't have any challenges to the body of the report and no challenges to the scoring guidelines as well.
All right, Ms. Goodrich, do the people have any additions, corrections, or scoring challenges?
No, Your Honor.
Mr. Gurmurthy, anything you want to say on behalf of your client?
I do, Judge. Thank you, Judge. Mr. Jarman is 35 years of age. This is a tough case. This is a tough case all the way around. Victim in this case was 11 at the time I think the disclosures were made. She's probably 12 now. Mr. Jarman had some legal challenges in this matter while we were at least litigating this matter. But in reviewing the evidence, the plea offers, the sentencing guidelines, the Alpina case, and how we resolved it, I think it made sense to resolve it the way we did. Mr. Jarman certainly has been remorseful and apologetic for his conduct. Mr. Jarman comes with his own set of challenges. He has some mental impairments that affect his ability to process and process things. Again, it's not a defense to what happened in this matter, but it certainly goes to why Mr. Jarman is in the position that he is. Mr. Jarman takes things very simple and understands things in a very, very simplistic manner and doesn't process the seriousness and the conduct and his actions the way they are. I certainly am hopeful that with the 8-year cap that we have, Mr. Jarman gets the necessary help that he needs to get while he's incarcerated in prison, goes through the proper courses and educations that are available to him while he's incarcerated. He has done so while he was in jail here. CMH was involved. I think they've reviewed his medication. So those things, at least while Mr. Jarman was here locally, have started. Mr. Jarman has support of his family as well. And it is important to also know that Mr. Jarman did waive the prelim in this matter. We were set for an exam. We again evaluated our case at the time of the exam, and he didn't put the victim through any testimony and go through the prelim. So I think that's also to his benefit to understand the ramifications of how this process works. And certainly it resolves the Alpina case that's pending as well, because now the victim doesn't have to testify in 2 counties and in the same matter with similar allegations. I would ask you to follow the sentence agreement in this matter. I think we scored Mr. Jarman. The family was on board. This makes sense overall for the family, for Mr. Jarman in resolution of this case. And again, as I said, Judge, Mr. Jarman is apologetic, difficult case. But I think it makes sense to resolve it the way we did. So I'd ask you to follow the sentence agreement and then sentence Mr. Jarman accordingly. I know we talked before we went on the record about the lifetime monitoring issue. I think the court needs to address that in the report. Mr. Jarman indicates that he's going to be moving to Florida once he's released from prison. And he believes that he wouldn't have to be on the lifetime monitoring once he's in Florida. I don't know what Florida law is, but the way the statute reads here in Michigan and the way the law is today, I think the court has to order lifetime monitoring, and certainly if Mr. Jarman leaves and goes elsewhere in another state, he can certainly take the actions to petition the court at that point. But that's all I have, Judge.
Thank you, Mr. Gilmore. Mr. Jarman, you don't have to say anything today, but you're allowed to. Is there any statement you want to make or no?
I do want to say that I'm sorry. I know I have made many mistakes over the course of my life. I've been in front of the courts countless times. I can't remember how many times I've been in front of courts, but this one's really woken me up and shown me that I do need to change my life. It's been a real eye-opener.
All right, thank you, Mr. Chairman. Ms. Goodrich, any recommendations from people?
Yes, Your Honor, thank you. The defendant is 35 years old with no prior felonies. He has 3 prior misdemeanors. He's unemployed with a high school diploma. He did make some admissions to the police about engaging in sexual acts with a relative who was under 13 at the time. The plea agreement was that any incarceration would not exceed 96 months. The recommendation for incarceration is 8 years, which is consistent with the plea agreement. I would ask the court to follow the PSI recommendations as well as order lifetime electronic monitoring. Thank you.
Thank you. Mr. Jarman, if you please stand for the court sentence. Mr. Jarman, you're in front of the court now for sentencing on 3 criminal sexual offenses against a child. And today, you tell me, gee, I've been in front of courts a lot, but never really understood, the changes I have to make. Well, it's a real shame to this victim that you didn't understand those things, because now she's got a lot that she's got to carry. And, you're here today, I'm sure the normal thing is you're focused on kind of what's ahead for you on your path, and there's some hard things there. But you've earned those hard things. You put hard things in this child's path that she didn't deserve or earn. So that's something you got to live with. There is a sentence agreement for 96-month sentence or cap, and that is within the advisory guidelines in all 3 files. And it sounds like it was reached with careful consultation between the prosecutor's office and 2 different counties and the victim and her family. And so for that reason, I'm going to go ahead and follow the recommendations of the Department of Corrections and the plea agreement. In all 3 counts, order concurrent sentences and commit you to the Michigan Department of Corrections for not less than 96 months nor more than 15 years. So that's 8 years to 15 years. You get credit for 272 days previously served. There's a crime victims assessment of $130, state cost of $204. And also on the, due to the 2nd degree CSC with a person under 13 and you being over 17, I am going to order as part of the judgment of sentence, the statutorily required sentence that upon any parole from prison, that you are subject to lifetime electronic monitoring. Mr. Jarman, that's the sentence of the court. I think it's proportionate. It's within the guidelines and consistent with the plea agreement. If you wish to appeal, you'd have to file an application to the Court of Appeals. If you wanted a lawyer, you'd have to make that request within 6 months. And if you did so, I would appoint a lawyer for you for the appeal. And you hand you a piece of paper about that appeal. Ask you to initial 1 copy. That's just so we have a record we gave it to you. The other piece of paper is for you to fill out if you do want to take an appeal and get a lawyer. Do you understand that? Any questions for me, Mr. Chairman? Good luck to you.
For the record, Judge, Mr. Jarman does acknowledge his appeal paperwork.
Thank you. Mr. Gerber, please conclude your matters today.
No, sir, thank you.
Okay. Oh, I don't know who this is. I gotta bring somebody in that says group series. Let me see who this is.
Okay. Okay.
Hello, there's somebody that says group series. Can you tell me who this is?
Tracy Strait.
Oh, okay. Mr. Gilbert, we've got Tracy Strait zooming in, at least by audio. Looks like there's no camera activated.
Yep, I'm
Says
getting
2-3.
it right now.
Okay, that's fine. We're here just for a status conference and people be straight, file 23-6658FH. Got Ms. Strait zooming in from where she's in treatment. Mr. Gilbert, her lawyer, is present in the courtroom along with the prosecuting attorney, Ms. Goodrich. And we're here for a status conference. It looks like she's still receiving treatment geared towards a goal of restoring competency. Anything that the defense wants to place on the record today?
Your Honor, just that's what my understanding is also is that she's continuing to receive treatment. There was a question, and I believe at our last hearing that I was going to look into and see how far along in the process she is. It appears that she's approximately about halfway through the statutory requirement. I was a little bit shy of halfway through the statutory requirement of 15 months. So we're not close to that time period yet.
Okay, Ms. Goodrich, anything people want to place on the record, or Mr. Juliet?
No, Your Honor, I agree with Mr. Gilbert.
Okay, so Ms. Strait, what we're going to do is your job is just to continue your course of treatment where you're at, and I'll set this for status conference just so that we don't wait too long. We'll call the case periodically. So we'll set our next status conference for August 12th at 2 p.m. and allow Zoom appearance. Of course, if we get any updated report from the treatment center that requires additional hearing, we'll schedule that on a sooner basis and go from there.
Thank you, Your Honor.
All right, Ms. Strait, you have a good day.
You too, thank you. And just for the court, you guys are just going to have another status conference in August, correct?
That's correct. I just like to do that from time to time so I don't lose a handle on the case and we can carefully calibrate if we're getting close to the 15-month mark. But if you guys send me a report that she's restored or can't be restored, we'll trigger a hearing within 5 days.
Okay, all right, thank you, sir.
Okay, thank you.
Yeah, bye-bye.
Okay, I am told that there is a Ms. Strack in the courtroom, or did she leave?
Yes.
Ms. Strack, your case was adjourned on the request of your counsel. So you do not have to stick around. Your next date is July 8th at 1:30.
Okay.
Okay. Yep.
You have a nice day.
You too. All right, Mr. Keough, I see Mr. Kraft zooming in. I'm told you're coming in on this case?
That's correct, Judge. In fact, I would have filed my paperwork, but the payment just came in and I haven't gotten the signed retainer. I think we're in the process of doing it. I should have paperwork filed.
Okay. Okay, so you want Mr. Gilbert to appear for this, or you want?
That's fine. He can for this. I'm just looking for adjournment to July 22nd. I think I'm here at 3:10.
Okay, let's bring in Mr. Kraft. All right, Mr. Kraft appears to be in the meeting. Just see if we can turn on his microphone here, video.
Good afternoon, Your Honor.
All right, good afternoon, Mr. Kraft. This is People v. Russell Kraft, file 25-6988FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Blaine County Prosecutor.
And good afternoon, Your Honor. James Gilbert here on behalf of Mr. Kraft.
All right, and I was advised before we went on the record, Mr. Kraft, that you are hiring Mr. Bill Keough to represent you. He's present in the courtroom today and advised us of the same. And He's requesting that we put this out to July 22nd so that you and he have a chance to review things. Does that sound okay to you, Mr. Kraft?
Very good, sir. Thank you.
Any objection to that, Ms. Goodrich?
No objection.
Yeah, Mr. I'm sorry, Mr. Gilbert, I presume you don't have any problem?
No objection, just wish Mr. Kraft best of luck.
All right, so we'll continue the docket call to July 22nd at 3:10 in the afternoon. I will allow Zoom appearances for both Mr. Kraft and or counsel. Okay, you're all set today, Mr. Kraft.
Thank you, Your Honor.
And we've got an arraignment in Foley. I've got a couple people, I don't know who they are.
I have, my numbers for Mr. Foley did not work, so.
Okay, let's see. Good afternoon. What is your name, sir?
Richard Dech.
Richard Dech. All right, this is People v. Richard Dech, file 25-7014. Up for docket call. Mr. Dech is zooming in. His lawyer, Mr. Gilbert's here with the prosecuting attorney, Ms. Goodrich. I do have this calendared as an in-person hearing, Mr. Dech. Why are you not in court?
Your Honor, I might have screwed that up. That's due to the fact that I thought we were gonna have the case dismissed because Mr. Dech is going to be applying to the recovery court. And he's gonna be here tomorrow to fill out the application.
Oh, okay.
And so.
All right, well, I'll excuse that today. Your lawyer fell on the sword for you, Mr. Dech. You're all good. All right, so there is an application that's gonna be filed?
Yes, and just the prosecutor and I talked and we were gonna have today's hearing and dismiss after the application's received.
Oh, this is gonna be, is this one where there was a prelim that was run?
Yes.
And there's a procedural hiccup then?
Okay.
All right. So, and you're certain that that's the direction we're going, where I don't need to set another hearing date?
Well, it depends on, we just wanted to wait to see what the team decides on his application, because he hasn't gone through that process yet.
There was two in the same status. One the team has already had input on, this one the team hasn't. They're co-defendants.
Well, let's schedule this then for let's schedule this for docket call on July 8th at 2:30. And that one, I will say, all right, so Mr. Dietz, your next court date with me will be July 8th at 2:30. However, if your recovery court application is going to go forward, stay in touch with Mr. Gilbert, because it's possible that this case will be dismissed here and you won't have that July hearing, but you'll have to be back in district court, then come back up here. So we'll rely on Mr. Gilbert to navigate that for you, okay? But unless he tells you otherwise, July 8th at 2:30 in my courtroom, okay?
Yes, sir.
Okay, we'll see you then. Thank you. This is a Cam's phone deal. Oh, that would probably be
Heapner.
All right, are you Mr. Murd?
Yes, Your Honor, I am.
All right, we have next an arraignment in two files. People v. Christopher Murd, file 25-7031 and 7032. Counsel, you want to state your appearances, please?
Anthony Julie on behalf of people. And good afternoon, Your Honor. James Gilbert here on behalf of Mr. Murd.
All right, we're here for an arraignment in both of these files. Do you or Mr. Murd wish to have the allegations read?
I don't believe Mr. Murday, I believe Mr. Murday is aware of his allegations and does not want them read.
Okay, Mr. Murday, you want me to read the charges against you into the record, or are you aware of them and you're waiving your reading?
I would like them to be read, Your Honor.
No problem. In file 7031, it's alleged, Mr. Murday, that you did possess metallic knuckles constituting the felony crime of possession of a dangerous weapon. The penalty with a habitual fourth notice that the prosecutors filed would be up to life in prison and or a $2,500 fine with mandatory forfeiture of the weapon or device. The reason why that's increased from 5 years to life is a habitual fourth notice, alleging that you have prior convictions in 2009 of home invasion second degree in Saginaw County, in 2010 for receiving and concealing firearms in Charlevoix County, 2010 for home invasion second degree in Antrim County, and 2010 for criminal enterprise, but it does not say which county that was in. In file 7032, Mr. Murday, it's alleged in count 1 that you did buy, receive, possess, conceal, or aid in the concealment of a 2024 Kawasaki KRT 800 side-by-side UTV, stolen or embezzled or converted property, knowing or having reason to know or reason to believe that the property was stolen, embezzled, or converted, and the value of the property was $20,000 or more. That's a felony punishable by up to 10 years and or $15,000 or 3 times the value. But there is also a habitual fourth notice with the same alleged prior crimes, which would increase the penalty to life in prison. Count 2 is that you did buy, receive, possess, conceal, or aid in the concealment of a 2024 Kawasaki KRT 800 side-by-side UTV, a stolen motor vehicle, knowing or having reason to know or reason to believe that the motor vehicle was stolen, embezzled, or converted. That's a felony punishable by 5 years and or $10,000 fine or 3 times the value. With the habitual notice, it increases that as well to life maximum. Count 3 alleges that you did buy, receive, possess, conceal, or aid in the concealment of 4 UTV tires on rims for a 2012 Kawasaki side-by-side stolen, embezzled, or converted property, knowing or having reason to know or reason to believe that the property was stolen, embezzled, or converted, and the value of that property was $200 or more, but less than $1,000. That charge would be a misdemeanor crime punishable by a maximum of 1 year in jail and or $2,000 fine or 3 times the value. On all 3 of those charges, the court can also order reimbursement to state or local government for the expenses of prosecution or emergency response. And Mr. Gilbert, do you know how Mr. Murday wishes to plead to those charges?
Still stand mute at this time.
We'll enter a plea of not guilty for you, Mr. Murday, on all those charges. Is a forensic center referral requested?
It is not.
What's the estimated length of trial on all 2 of these? Or
2 days.
Your Honor.
2 days each? Yes, sir.
Can I put something on the record? And I got an issue going on that I need to address to the court.
Okay, I'm going to caution you that your lawyers get real nervous when the defendant just starts saying things in court that they don't necessarily know what they're going to say. So I want to caution you not to say anything about the facts of your case, because the prosecutor's sitting right here. This is live streamed. It is on the record. We're making a transcript of it, and anything you say, the prosecutor could use against you in court to prove your guilt. So do you understand that, sir?
I do, Your Honor.
Okay, so what do you want to tell me, sir?
So I believe I received ineffective assistance of counsel in the lower court, and I believe there's multiple issues of communication going on between me and my lawyer. And I believe there's probably 5 or 6 prosecutor or professional rules of misconduct that he's violated, and I would like him to be removed from my case for ineffective assistance of counsel in the lower court and for a breakdown of communication between me and him. And if you would like to know the detail, I can give you the detail that I believe would put it well within the standard of ineffective assistance I've received in the lower court on his behalf.
Okay, well, here's what I'll say about that is you would need to file a written motion so that the prosecutor has notice of that and an opportunity to respond, and you can put the details of that in. But I'll tell you this, before we called your case, the defense attorney did want to let me know that he had tried to set up a visit with you, and the Otsego County Jail had some issues with the day that he was going to be doing that, and couldn't really accommodate that. So that he wanted to discuss with you a prosecutor's motion that we're going to not hear today. We're going to continue it so that Mr. Gilbert has a chance to meet with you. He did state off the record with all of us present that it's his intention to physically get down to Otsego County and meet with you in person at that jail within the next couple days. So I'm going to suggest that you do have the right to ask for substitute counsel, but I'm going to ask you to hold off on that until you talk to Mr. Gilbert in person, see where you're at after that meeting. If you believe that you still need to make that request, you'll have to submit that as a written motion. If you don't have a motion form, if you send a letter to me, I'll put it on the docket for us to consider that, okay?
I guess I don't understand. I guess I don't understand. All right.
Okay. I'm just telling you, Mr. Gilbert tells me he's been trying to contact you and had some logistical problems. So
Your
before I
Honor,
would decide on substitute counsel, I'd want to make sure that he's actually able to communicate with you. Okay?
Your Honor, I, for the last 3 months, have been trying to get the evidence in my case from Gilbert, and he has failed to give me the photos, videos, and audio for me to review. And I made it clear I did not want to go through my lower court hearing without reviewing the evidence. And still today, I don't have the evidence or reviewed of it. And I've even told him I've had evidence showing that my crime don't fit the statute that I'm being charged with, and he does not want to look at it. He does not want to take a copy of it. He did not want to argue it in the lower court. And I believe that's failed to give me, it's ineffective assistance of counsel for allowing it to be bound over without arguing this and having it dismissed in the lower court. So, I mean, I'm strongly urging that I have him removed from the case and have a lawyer appointed that will do his due diligence in the matter and communicate with me on the stuff. And I will put a letter in to you on the request. I contacted the court already prior to this, and the court told me I had to just address this with you with the issue.
Okay. Well, I'm not going to grant that request at this time because Mr. Gilbert did explain to us he's got a stack of stuff about this thick he's bringing down to go through with you. If after that meeting you want to submit a request for a new attorney, send a letter or motion up, and we'll hear that at the next docket. And I'm going to schedule this for a docket call in both cases and continue the prosecutor's motion to amend. For example, the prosecutor's got a motion to amend the charges. I don't know if that's going to address your concerns or not, but Mr. Gilbert will go over that with you and see where you're at. So I'm not going to hear the prosecutor's motion today because I want you to have a chance to review that with Mr. Gilbert. We'll hear the prosecutor's motion and call the case for a docket call in both files on July 22nd at 2:40 in the afternoon and allow Zoom appearances. Anything further from the people?
No, thank you.
Anything further from the defense?
No, Your Honor, thank you.
All right, Mr. Murd, Mr. Gilbert will be down to see you soon. If after that you still want to ask for a new lawyer, you just submit a letter of motion, okay?
Thank you, Your Honor. Have a great day.
All right, you too. All right, and this is Miss Mayfield, let's call that. This is People v. Ayanna Mayfield. It's file 25-7012 FH. And Mr. Gilbert, what's our status here with Miss Mayfield?
Your Honor, the prosecutor and I have met, and also I've met with my client, and we do have a signed plea agreement.
Ms. Mayfield, would you please stand and raise your right hand as best you can for me? Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, put your hand down. Ms. Mayfield, a guilty plea hearing is an important event. It includes the waiver of constitutional rights that you have. So I want you to listen carefully. If you've got a question, ask it. We'll do our best to answer it. If you need more time to talk to Mr. Gilbert, you just let us know. Does that sound all right?
Sir.
Now I have to advise you the maximum penalty that you could face for the charges that you're offering to plead to. Count one is a charge of no account check. And that is a felony punishable by up to 2 years in prison and or a $500 fine. Count 19 is a charge of Non-sufficient funds checks, 3 within 10 days. That's a felony punishable by, again, 2 years and or $500 fine. Do you understand the maximum penalty that you could face?
Yes,
Did you read and understand the advice of rights form?
yes,
And you signed that form today?
yes,
And that form lists several rights that you give up when you enter a plea. Do you understand that?
yes.
Do you have any questions for me or Mr. Gilbert about any of those rights?
No.
And do you wish to give up those rights and enter this plea today?
Yes,
If I accept your plea, you give up any claim that it was caused by any threats or any promises beyond the plea agreement or any other inducements at all. Do you understand that?
yes,
Also, when you enter a plea, you lose the right to appeal. If you wanted to appeal, you'd have to seek permission to appeal. You would do so by filing an application, but the types of issues you could raise in that application are very limited, much more limited than if you were convicted after a trial. Do you understand that?
yes,
The plea agreement provides in exchange for your plea of guilty to those 2 charges, the prosecutor will dismiss the remaining counts and the habitual enhancement. There's restitution agreed upon of $1,423.06. And there's a sentence agreement for no immediate jail. Do you understand the terms of that plea agreement?
yes.
Mr. Gilbert, is that a full, fair, and accurate statement of the terms of the agreement?
It is, thank you.
Ms. Goodrich? I'm sorry, Mr. Juliet. I'm
Yes.
sorry, I forgot this is yours. We met in chambers and I forgot the. All right, Ms. Mayfield, the sentence agreement for no immediate jail is not binding on me. I did talk with your attorney and the prosecutor in chambers, and I'm familiar a bit with you because you're serving a sentence of mine right now. And I told them that this probably sounds like a good something I could go along with. That's not a promise. I got to wait till I see the pre-sentence report. So I don't have to follow it. But if I didn't follow this agreement, you'd have the right to withdraw your plea. Do you understand that? Now, Mr. Gilbert even circled on the advice of rights form because he wanted to go over it with you carefully. But I'm required to tell you and remind you, you understand, if you engage in any misconduct between now and the sentencing, you're about to finish serving my sentence, right?
Yes.
So then if you post this bond and you're out, if you don't show up for court, or you violate conditions of your bond, or you commit a new crime, then when we come back for sentencing, all bets are off. I don't have to follow that sentence agreement. I can send you back to jail, but you would have lost the right to withdraw the plea by your own misconduct. Do you understand that?
Yes.
Other than the plea agreement, has anybody promised you anything to get you to plead guilty?
No.
Has anybody threatened you to make you?
No.
Is it your own free choice to enter that plea?
Yes.
Knowing all this, how do you wish to plead the charge in count 1, no account check?
Guilty.
And how do you wish to plead the charge in count 19, non-sufficient funds, 3 within 10, check?
Guilty.
So Ms. Mayfield, back between July and November of 2024, were you living in Sheboygan County?
Yes.
While you were in Sheboygan County, did you tender a check where you actually did not have an account?
Yes.
Okay. And count 1 says this was back on November 3rd of 2024 for $57.74, payable to Easy Mart.
Yes.
And you tendered that check to them on that date?
Yes.
And did not have an account?
Yes.
And that was in Sheboygan County?
Yes.
Count 19 alleges that in a period of 10 days from November 3rd to then November 13th, that you submitted checks of $57.54, $31.65, and $41.97 on a PNC account, knowing that you did not have sufficient funds to cover those checks. Is that true?
Yes.
And did you tender those checks in Sheboygan County?
Yes.
You knew that you didn't have sufficient funds to cover those checks? Mr. Gilbert, are you satisfied with the factual basis?
I am, Your Honor. Thank you.
Mr. Juliet?
I am as well.
And Mr. Gilbert, are you aware of any other promise, instruction, inducements?
I am not.
In your judgment, has the court complied with 6.302?
I believe the court has. Thank you.
Mr. Juliet, do you agree on both counts?
I do.
All right, Ms. Mayfield, I find that your plea is knowingly, understandingly, and voluntarily made, that there is a sufficient basis in fact and law to believe you're guilty of those offenses. So I hereby accept your plea. All right, we'll schedule sentencing for August 12th at 2:20. You'll have to cooperate with a pre-sentence interview so they can prepare a report for me. And anything further from the defense?
Your Honor, if we could have the bond modified for it to be a PR bond, just to update the court a little bit more than when we met in chambers. Ms. Mayfield has a case going on for an Emmett, which she won't be released until September, I believe. So there will be even more jail time than we initially thought when drafting up Leaver. So.
Okay. But so she won't be released before the August 12th. Anyway?
No, she will not be.
Okay, so we don't need to amend the bond at all then.
Yeah, that makes sense too. Okay. Absolutely right.
Okay, so then we'll have to, Mr. Juliet, you have to watch that, because then if she's done with my sentence here and she's in the Emmett County Jail, we'll need a writ to bring her over for the sentencing. Anything further from the people?
No, thank you.
From the defense?
No, Your Honor, thank you.
All right, we'll see you in August, Mr. Mayfield. Is this Mr. Stein?
Yes.
Right, so next up, we've got a sentencing. We might not need Mr. Page on it. We'll bring in Mr. Clean. We do not. He's able to join or not. I was just informed by staff that Mr. Clean contacted. He just appeared to Mr. Page, and he'd like that heard tomorrow when he's here on Kiefer anyway. Any objection to that?
Handling that one, so.
Okay. Here he is. All right, Mr. Clayton, I just got a request that you'd like us to call Mr. Page tomorrow morning when you're here. Does that sound all right?
Just anytime tomorrow, sir. I plan on being there the entire day. I don't have anything else scheduled.
Okay, so we'll continue Mr. Page to tomorrow morning. We'll pass the case till Mr. Clayton's here with him all day tomorrow, and we'll, at an appropriate time on a break, we'll bring up Mr. Page and we'll cover it then.
All right, thanks, sir.
Okay, thank you. See you tomorrow.
Bye.
All right, so we have next people be Matthew Stocking, 25-7015FH, up for a continuation of sentencing. We had the sentencing hearing last week, and the court announced a sentence which was outside the terms of the sentence agreement and continued it for Mr. Stocking to consult with his attorney to determine whether he wished to withdraw his plea. Mr. Gilbert, if he had time to review that with Mr. Stocking.
Mr. Stocking and I have discussed this matter. We have an unusual request for you, Your Honor, is that Mr. Stocking would like to allocute to you about his accomplishments and that type thing, if that would possibly change the court's mind and not following the plea agreement or even modifying it a little bit differently. But we discussed that if the court would entertain that, is that possibly the court would allow Mr. Stocking to have a 1-year delay and see, because we got the impression that the court did not believe he'd learned his lesson. And so Mr. Stocking was asking if the court would possibly consider allowing him out on a 1-year delay, seeing how he did during that 1 year. And at the completion of that 1-year delay, he comes back and finishes whatever jail term for the rest of the 1-year cap. And if he doesn't fulfill any of the probation terms during that time period, then be sentenced to prison. And so he can demonstrate to you that he does have the ability to correct his behavior. And I don't know if that's something the court would entertain, or at least listen to Mr. Stocking allocute for himself on that.
Well, I mean, I certainly, I don't think it's inappropriate for me to reopen allocution to hear what you or Mr. Stocking would have to say and hear from the prosecutor as well. I mean, I'll be honest with you, I cannot imagine a set of circumstances where I end up at a delay, given the prior history and the prior sentencing history. But I certainly, you know, this is a continuation of the sentencing hearing. I guess, Ms. Goodrich, would you have any objection to reopening allocution?
I would have no objection to it.
All right, so Mr. Gilbert, is there anything additional you want to say?
Well, as I just outlined briefly, I'll hand it over to Mr. Stocking, but this wouldn't be necessarily just an ordinary delay. He would, in essence, serve the complete jail time that is part of the plea, just in 2 separate portions, with basically a period in which he can prove to you that he does have the abilities to be a successful member of society. And so it's like I said, a little bit different twist on just a straight delay. So we would ask the court, and I'll hand it over to Mr. Stocking. I know he has a lot of things that he's accomplished in the jail during this time period, and has worked on a statement that he would like to discuss. Thank you.
Thank you. Mr. Stocking, anything further you want to tell me? Go ahead.
I would like to ask you to reconsider the time that you were looking to impose upon me. I know I've chose to make the wrong decisions in the past. While being incarcerated in the county jail this time, I've been trying to better myself. I've been going to AA twice a week, and I've been attending church services 3 times a week. They pass out tablets in the jail that have courses on them, and I have completed some of the courses since I've been here. At the last 100 days, I've done some soul searching on the things that I've done to put me back in the situation. I know, or I have been trying to make my life better. I've been trying to overcome the choices that I have made to screw up my life again. And if you give me this last chance to prove to you and to this court that I'm working on making my life better, if you give me a chance to show you, I plan on getting into counseling and other resources to better myself, because I can't keep doing this to my family. I have three minor children that are 7, 4, and 3. And if I continue down this road, what kind of life is that for them? I want to show them how to be productive members in this community, and being locked up is not a way to teach them. So again, I'm asking this court and you to consider giving me a 1-year delay sentence on probation. And after I show you that I can complete this, it will give a further support for you to reconsider granting me the 1-year probation, or 1-year jail with a 2 years probation. Thank you for listening.
Thank you, Mr. Stocking. Ms. Goodrich, any additional recommendations since I've reopened allocution?
Your Honor, just that I still agree with the PSI recommendation for 12 months jail, which is consistent with our plea agreement for the county jail cap. It does look like he is facing sentencing on July 8th in Emmett County for that failure to register that's mentioned in the PSI.
All right, well, Mr. Stocking, I don't have to go through everything today. It's not a full sentencing hearing. We're continuing the sentencing hearing from last week, and this is all one record. And I've allowed you to make some additional statements. So I'm not going to go through all of it again, but just in summary, you're 41, you've got a sexual assault, 4 prior domestic assaults, 2 prior weapons cases in prison, a child abuse conviction, and a drunk driving while you're on parole. I mean, and as I outlined, 2 times in the past on a domestic violence third, you got a year in jail. So I just can't abide giving you another year in jail. This case and your record cries out to me for prison. This is not the end of the road for you. I announced that I would give a sentence of 3 years to 20 years with the credit that you've served. That's the sentence that I would impose today. And so you would likely, unless you gather more weapons cases when you're in prison, if you've learned your lesson, and as you're telling me today, you wouldn't. So assuming you behaved in prison, you'd be paroled in your mid-40s and still have an opportunity to be involved in your kid's life and still do good things with your life. So it's not like this is the give me one last chance before I'm in prison forever. This is not a life sentence for you today. You seem to me to be doing life in installment payments. And I am saying that it's my intention to give you your next installment of a 3-year minimum. So again, you have the right to withdraw your plea if you wish, since that goes beyond your county cap, or to proceed to imposition of my sentence. So I gave you time to think about that. What is your decision, Mr. Stock?
Can I have 5 minutes to talk to my mother for a minute?
You may not. You can, I mean, I adjourned this a week for you to talk with your attorney. And you're in custody. This is not visiting hours. And for me to allow in custody defendants to consult with their family members raises security concerns in the courtroom. I'm not going to allow you to have contact with another person in the gallery so that you can do anything stupid.
That's not what my intention is.
I believe that to be true, but that's a pretty bad precedent for me to set, to allow in custody defenders to have contact with folks in the gallery, so that can't happen. If you need a couple minutes to talk with your attorney with a final thought, I can give you some white noise and you can sit down and do that at the table with them right now. Yes, let's do that. All right, we're back on the record, and I've given Mr. Stocking some additional moments to consult with his attorney. And Mr. Stocking, the question is back into your court, whether you wish to continue with imposition of the sentence I announced or withdraw your plea.
I guess I'll speak on behalf of Mr. Stocking, and this is consistent with our conversation prior to today's hearing. He'd like to withdraw his plea at this time.
So we'll go ahead and withdraw your allow withdrawal of the plea. We'll go back into a pretrial posture. There was no amended information that was filed. Is that correct for the plea? So you can just go forward with file date then. Let's come back then for a docket call for us to see what we're going to do scheduling wise. We'll come back on we'll come back for a docket call on July 8th at 2:40 in the afternoon. Anything further from the people?
Yeah, thank you.
Anything further from the defense?
Nothing, Your Honor. Thank you very much.
Okay, so Mr. Stocking, I'll see you next on July 8th at 2:40, and then we can discuss trial schedule.
Oh, Your Honor, he does have that Emmett County sentencing. It looks like at 1 p.m. on July 8th.
Oh, is that, July 8th, you have a sentencing in Emmett?
Yes, sir. Yes, Your Honor.
Have you gotten a pre-sentence report on that yet?
I have got a pre-sentence investigation.
Okay.
Yes.
All right, well, why don't we set this for after that? So that makes sense. Couldn't really do it before then anyway. So we'll continue the docket call to July 22nd at 2:50. All right, thank you for bringing that to my attention. Anything else from the people,
No, Your Honor.
from the defense? Anything further from the defense, Mr. Gilbert?
No, Your Honor, thank you very much.
Okay, we'll see you on July 22nd, Mr. Stein.
Yeah. Your Honor, what time was that again?
2:50.
2:50.
I do have a prison, I think it's probably Mr. Field.
Your Honor, Mr. Field was in quarantine. He was one I could not talk with.
Okay, gotcha.
That was my understanding.
All right, Mr. Field, can you see us, hear us?
I can hear you, but I can't, there's the content of this meeting is being sent through one or more apps. I can't see your faces.
Oh, okay, yeah, you may need to hit a button on the remote for the Polycom to take away a message that's up on it.
It went away.
Okay. All right, this is People v. Aaron Field. It's file 24-6914FH. Mr. Field's appearing by video from the Department of Corrections where he's serving a sentence in another case. His lawyer, Mr. Gilbert's here in the courtroom. Prosecuting attorney, Ms. Goodrich, is present, and we're here for a docket call. And we were going to be looking at setting a jury trial date, but Mr. Gilbert informs us because of your in-processing into the Department of Corrections, there are some quarantine restrictions when you're going through that he has not had time to really discuss with you the timing of the trial and what we're doing on that. So Mr. Gilbert, what would be your request at this point?
I don't know if the court want to give me a breakout room at this time. If not, I would ask that this be scheduled for I'd really like to talk to Mr. Field and be able to either meet with him in person, go wherever he's at, or talk to him via telephone. But I know during that quarantine, Mr. Field, you're still in quarantine, aren't you?
Negative.
Okay, all right.
I'm going to see St. Louis.
Okay, I guess he's at establishment.
Okay. You want me to just continue this to July 8th?
That'd be fine, Your Honor. Then I will make sure I get a hold of St. Louis.
All right, so Mr. Field, I'm going to continue this to July 8th at 2:40 so that Mr. Gilbert's got a chance to talk with you and see if we need to schedule jury trial in this new one. And then on July 8th, we can go ahead and pick some dates and get that on the calendar. Okay. Anything additional from the people?
Your Honor, we did receive the 180-day notice on May 29th, so that would expire November 25th.
Okay. 80-day, November 25th. Okay, anything further from the defense?
No, Your Honor, I do apologize. I thought it was in quarantine for 90
That's all
days.
right. I think that probably would have been a recent change. All right, Mr. Field, Mr. Gilbert's going to talk with you, not today. We've got to cover a bunch of other cases today, but he's going to visit with you at least by video at your facility, and we'll call your case back on July 8th, and if necessary, we'll get you a trial date at that time, okay? You have a good day.
Good day.
I've got Mr. Heapner. All right, next we have People v. Camden Heapner, file 24-6921FH. Mr. Heppner's appearing by Zoom video, and Mr. Gilbert's here in the courtroom on his behalf. And who's here for the people on this one?
My case, Your Honor.
All right, Mr. Juliet's here for the people. And Mr. Gilbert, what's our status here?
Oh, Your Honor, Mr. Heppner and I have been talking about his case, and he did at our last docket call allow us to adjourn the trial that was scheduled. And we're asking for one more docket call. At that point in time, we will either set it for trial or have it resolved.
Okay, any objection, Mr. Juliet?
No, Your Honor.
Okay. All right, so Mr. Heppner, we're going to continue this then to July 8th at 2:40. Where do you live, Mr. Heapner?
In Saginaw.
Oh, that's right. Okay. All right. That's why I'm letting you appear by Zoom. But we'll allow Zoom appearances at that hearing, July 8th at 2:40 in the afternoon.
Okay.
Anything else from the people?
No, thank you.
From the defense?
No, Your Honor, thank you very much.
Okay, we'll see you then, Mr. Heapner.
All right. Thank you.
Good day. And looping back, about 51 minutes ago, we had scheduled arraignments in 2 files and People v. Jonathan Foley. Mr. Foley is not present in the courtroom and has not zoomed in. It's up for arraignment. Mr. Gilbert, any information about Mr. Foley's?
The number that I have, Your Honor, I tried a couple of times and it was not successful, did not go through.
Okay. Miss Goodrich?
Your Honor, I'd ask that show cause be issued at this time.
All right, well, we'll continue the arraignments then to July 8th at 2 p.m. And this being the first failure to appear and there being no show causes in the file. I would also set it for an order to show cause on the same date and time in both files for Mr. Foley to show cause why he should not be held in contempt. Mr. Jolette's in the Emmett jail, right?
He is.
And Mr. Oliver, is he in the Chippewa jail?
He is.
Is Mr. Morrow present?
Your Honor, I am going to need a moment with Mr. Morrow and go over the matters that.
Okay. That's fine. Let's go off. Okay, we're back on the record and we're calling People v. Eric Morrow. Oh. File 23-6641FH. Counsel, you want to state your appearances, please?
Anthony Juliet, on behalf of people. And James Gilbert here on behalf of Mr. Morrow.
All right, and I have talked with counsel a bit about this case at previous hearings, and we did have a conference in chambers to discuss the court's concerns that whatever we do in the case would I'd want to see that we're addressing some mental health treatment for Mr. Morrow. We are here for a docket call. I have a plea agreement in front of me. Is that how we're proceeding today, Mr. Gilbert?
It is, Your Honor.
And the reason for no contest plea is that civil liability?
That and there is no recollection what happened that night too.
Oh, that's right, lack of memory. Right. And Mr. Juliet, any objection to a no contest plea?
No, Your Honor.
All right, Mr. Morrow, would you raise your right hand for me? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, you can put your hand down. Are you Eric Wayne Morrow II?
Yes.
Mr. Morrow, in a no contest plea, I won't ask you about what happened. I'll review what's been marked as Joint Exhibit 1. But I am going to ask you questions just to make sure that you understand what we're doing here today and what rights you're giving up. So at any time, if you have a question, ask me. If you need to talk to Mr. Gilbert, you just say so, okay?
All right.
Now, do you understand that a no contest plea has the same effect as a guilty plea in terms of my authority to sentence you for the crime?
Yes.
I have to advise you the maximum, or Mr. Gilbert, do you consent to the filing of the second amended information?
I do, thank you.
Okay, do you waive its reading?
I do waive the reading.
Okay, Mr. Morrow, added count 6, home invasion in the 3rd degree is a felony punishable by a maximum of 5 years in prison and or a $2,000 fine. Do you understand that maximum penalty?
Yes.
And did you read and understand the rights listed on the advice of rights form? And you signed that form?
Yes.
Do you understand the rights listed on that form?
Yes.
Do you have any questions for me or your lawyer about any of the rights you give up when you enter a plea?
No.
Do you wish to give up the rights listed on this form and enter a plea?
Remember, we actually need to give up those rights before we leave. So
yes.
Okay. Mr. Morrow, if I accept your plea, you also give up any argument that the plea was caused by promises that aren't put on the record today, or that Mr. Gilbert has twisted your arm, or anybody's twisted your arm, or anybody's threatened you to make you enter a plea. You give up any claims like that. If anything like that's going on, today is the day to tell me that. Tomorrow would be too late. Is anything like that going on?
No.
You understand you can't tell, tomorrow's too late to complain about that. You understand that?
Yes.
Now, when you enter a guilty plea or a no contest plea, I'm sorry, you lose the right to appeal. And if you wanted to appeal later on, you'd have to seek permission to appeal. You would do so by filing an application. But the types of issues you could raise on appeal after you enter a plea are very limited, much more limited than if you were convicted after trial. Do you understand this?
Yes.
Now, the plea agreement provides in exchange for your plea of no contest to count 6, the prosecutor will dismiss counts 1 through 5. Your attorney has requested that the court would do what's called a Cobb's evaluation, where I would give some evaluation based on what the facts as known to me in the complaint, what my sentence would be. And I have indicated that my initial evaluation would be if there's a sufficient plan for mental health treatment or protection, that the court would impose no upfront jail. Do you understand the terms of the agreement in that evaluation?
Yes.
Mr. Gilbert, is that a full, fair, and accurate statement of the terms of the agreement and the evaluation?
it is, Your Honor. Thank you.
Mr. Juliet?
It is.
Now, Mr. Morrow, once I get a full pre-sentence report, I might change my mind about that. But if I change my mind, you'd be allowed to withdraw your plea. Do you understand that?
Yes.
That's unless you get in trouble between now and the sentencing by either not showing up for court, committing a new crime, or violating bond conditions or court orders. Then I could give you jail, but you would have lost the right to withdraw the plea by your own bad conduct. Do you understand that?
Yes.
Other than this plea agreement and my preliminary evaluation, has anybody promised you anything to get you to plea?
No.
Has anybody threatened you to make you?
No.
Is it your own free choice to enter that plea?
Yes.
Knowing all this, how do you wish to plead to the charge of home invasion in the 3rd degree? Guilty, not guilty, or no contest?
No contest.
All right, and I have reviewed what's been marked as Joint Exhibit 1. I find that it does establish a factual basis for the offense in that Mr. Morrow entered a dwelling without permission in Chemung County at the alleged date and time, and that while entering, present, or exiting it, he did commit a larceny misdemeanor. Mr. Gilbert, are you satisfied that a factual basis has been established?
I am, Your Honor. Thank you.
Mr. Juliet?
I am as well.
Mr. Gilbert, are you aware of any other promises, threats, or inducements?
No, Your Honor.
Mr. Juliet?
I'm not.
And Mr. Gilbert, do you believe the court has fully complied with the requirements of MCR 6.302?
I believe the court has. Thank you.
Mr. Juliet?
Court has.
Mr. Morrow, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you're guilty of that offense. So I will accept your plea. I did talk with the attorneys about putting sentencing out a while because, as I understand, Mr. Gilbert, there's a guardianship petition that's going to be heard in the probate court.
That is correct, Your Honor. And the evaluation is they're quite backlogged, so it's going to be a few months before that evaluation is complete.
Okay. And we talked about maybe putting sentencing out to October. Is that sufficient then?
I believe it will be.
Any objection to that, Mr. Juliet?
No, Your Honor.
Okay, just because, Mr. Morrow, my evaluation of what I want to do in this case kind of depends on what happens in probate court. So I want to wait and see what happens there. So we're going to put your sentencing out for a while. In the meantime, you're still on bond. You have to comply with bond. If you don't, we can cancel your bond and have you sit in jail. So we'll continue the sentencing out to October 7 at 2:10 p.m. Also, Mr. Morrow, you have to cooperate with an interview with the probation department so that they can write a report for me with their own recommendations about what we ought to do. So before you leave the day, stop by the probation department, tell them you entered a plea, and you need to schedule a pre-sentence interview. Okay? Do you have any questions for me, Mr. Morrow?
No.
Anything further from the people?
No, thank you.
Anything further from the defense?
No, Your Honor, thank you.
Okay, we'll see you in October, Mr. Morrow.
Again.
All right, let's let's call People Be Donald North, file 24-6778FH. This is a continued sentencing hearing. And at the last, and we've got Mr. North present in the courtroom along with the prosecuting attorney, Ms. Goodrich, and Mr. Gilbert for the defense. At the last hearing, the court, after the full allocution, announced an intended sentence of a minimum of 43 months in prison. Because that went beyond the terms of the sentence agreement, I adjourned it to allow Mr. North to consult with his attorney whether he wished to withdraw his plea or proceed to the imposition of sentence. Mr. Gilbert, have you had a chance to review that with Mr. North?
Mr. North and I did discuss it. Mr. North does not want to withdraw his plea at this time. However, we would ask that the court possibly consider a lower time than the 3 years, 7 months. I would just reiterate that a lot of this was mental health, and Mr. North is a lot different person than the person that did these activities. He has gone away and is on medication now, and his personality is completely different than when I met him during the arraignment. And so I asked the court to take that into consideration.
Okay, thank you, Mr. Gilbert. Mr. North, is there anything further you wanted to tell me today, sir?
Yeah, I'm just gonna ask that you show some mercy and grace, considering I have mental health illness.
Okay, thank you, sir. Ms. Goodrich, anything further from the people?
Nothing further, thank you.
All right, well, Mr. North, I had previously gone through all of the considerations that I was thinking of, so I don't need to go through all that. This is a continuation of one record. So on the, in this file, there's state costs of $312, the crime victims assessment of $130, court costs of $350. On the reckless driving charge, the court will order you serve 93 days jail with credit for 93 days served. On the resisting and obstructing habitual third, the court will order you serve 1 year in the county jail with credit for 1 year served. Count the fleeing and eluding fourth degree habitual third. The court will order you serve 1 year in the Sheboygan County Jail with credit for 1 year previously served. And on the charges of felonious assault habitual third and malicious destruction of police property habitual third, the court will commit you to the Michigan Department of Corrections for a term of not less than 43 months, nor more than years, exercising my discretion under the habitual guidelines to double the statutory maximum. I'll give you credit for 716 days previously served. Those sentences will run concurrent with each other. And the reason for imposing a top of the guideline sentence, despite the mitigating factors of mental health, is the extreme public safety risk, in addition to the multiple prior felonies for Mr. North, 7 prior felonies before this case. So that though that is the top end of the guidelines, I do believe it's proportionate under the circumstances of the offense and the offender. Mr. North, you may appeal that sentence if you wish by filing an application. If you want a lawyer, I'd give you one, but you'd have to make that request within 6 months of today. We're going to hand you a piece of paper explaining that, ask you to initial one copy for us. The other one is for you to fill out if you want to take an appeal. Good luck to you, sir.
Your Honor.
Yes.
You gave credit for 716.
Oh, yes, there'd be more.
It'd be
Yes,
723.
723. Yes, I'm sorry. On counts 1 and 2, it'd be 723 days credit because we did continue. Thank you, Mr. Philip. Oh, yes. Yeah. Oh, yeah. I'm sorry. And restitution was $12,246.50. And defense did not want a restitution here. Chippewa County Jail, so let's get them in so we can be respectful of their process here. All right, Mr. Oliver, is that you up in Chippewa there?
Yes, sir.
All right, up next, we have People v. Jeffrey Oliver. It's file 24-6979FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Wayne County Prosecutor.
Good afternoon, Your Honor. James Gilbert here on behalf of Mr. Oliver.
All right. We are scheduled for a docket call. We also have a bond violation hearing for the failing to appear that we've continued. I do also see and put on the docket, Mr. Oliver filed a handwritten motion in pro per asking for the appointment of substitute counsel. Mr. Oliver, did you still want to proceed with that request for a new attorney today?
Yes, Your Honor, I should even be in here on this matter due to that part.
I'm sorry?
I said, yes, Your Honor, I do.
Okay, I heard that, but you said you shouldn't even be in here, and then I didn't
Right.
catch the last part of that.
That the contempt of court shouldn't even be a process according to my counsel before this hand.
Your Honor, if I may interrupt,
Yeah.
I did receive the same motion, and I'm in concurrence that we probably have a breakdown to the point that I've submitted that to the MAC, and she is going to reassign the case that pleases the court to outside counsel so that he will get an attorney.
Okay, so Mr. Oliver, with the public attorneys at public expense are technically no longer court appointed anymore. They're their own appointment authority. And so I can order them to give you a new lawyer on a motion where it's necessary. Mr. Gilbert is saying that they agree that they'll reassign it to another assigned attorney. So the MIDC office will assign to new counsel. So we probably should continue your docket call so that the new attorney can review it with you. And the contempt hearing as well, I would want to continue that. It sounded though, Mr. Oliver, did you have a different opinion about that, about the contempt matter?
I would see rather do it with the new attorney.
You want to review it with the new attorney? Okay.
Yes, please.
Okay. And that's going to be outside counsel?
I believe so, yes.
Okay. can you remind me, Mr. Oliver, are you in pretrial detention in Chippewa County or serving a sentence there? What's your status in Chippewa?
Pre-trial sentence, sir.
Pretrial?
Yes.
All right. So you have not posted a bond there?
No, I've been waiting to get that one reinstated.
Okay. And if you did post up there, we have a hold on you for revoking here. So I just wanted to figure out where you'd be.
Yep.
Okay.
I'd
All right,
probably
well,
be
let's,
here.
I think I should continue this to July 22nd to allow sufficient time for them to find a new lawyer for you and for them to discuss that.
Okay.
So we'll
Thank you.
continue this to July 22nd at 11:20 a.m. With contempt status conference. Same time. Anything further from the people?
There.
There, thank you.
Okay. All right, Mr. Oliver, I'll see you on July 22nd with your new attorney then, okay?
Thank you.
This is Mr. Tunis. This is file 23-6679 and 25-7006 FH, People v. Howard Tunis. We've got prosecuting attorney Goodrich here and Mr. Gilbert for the defense. Mr. Tunis is with us in the courtroom. We're here for a docket call on both files and a contempt hearing for the failing to appear. Mr. Gilbert, what's our status?
Oh, Your Honor, this matter hasn't been resolved yet. However, Mr. Tunis and I had talked today, prior to today, about possible resolutions, and the prosecutor has given us another offer, which we would like to go through. I would ask for just one more docket call before we would set up a trial. I'm hoping it will be resolved at that time.
Any objection, Ms. Goodrich?
No objection.
Let's schedule this for a docket call on both matters and a continued status conference on the contempt for let's do July 8 at 2:50. All right, anything further, Mr. Gilbert?
No, Your Honor, thank you.
Ms. Goodrich?
No, Your Honor, thank you.
All right, we'll see you then, Mr. Cruz. We have a forfeiture hearing and People v. David Tully. So let me just double check there's a phone. Let me make sure that's not in there. All right, there's a Samsung phone that just entered through the Zoom waiting room. Can you turn on your camera and microphone and tell us who you are? Going once, going twice. Removed. All right, People v. David Tully, file 25-6996 FH. That's in warrant status and, is that your case, Mr. Gilbert, or no?
I inherited that one, Your Honor.
All right, that's in warrant status for failing to appear. We set it for, even though it's a personal recognizance bond at 10,000, we set it for a forfeiture hearing. Any information you would have that would prevent the entry of the forfeiture judgment against Mr. Tully?
The notes that I received, Your Honor, is that we have no contact information, no address, no email, no phone, that the client or defendant was homeless. And I guess the exact quote given to me was 99% chance that we'll probably never see him again.
Okay, we'll continue in warrant status and we'll enter the forfeiture judgment. Mr. Gillette never did zoom in from Emmett. 2:30. What we're doing on that, or whether you want to call over, or I was told that that's scheduled for trial. So do we just need to put these over?
I think so.
That was our plan.
Okay, so we don't need to pester Emmett about that then. All right, do you know when trial is scheduled for?
Early October.
Oh my. Is there any reason why either the defense or prosecution would want a hearing on the violation in these probation matters prior to that date?
I would.
Okay.
You don't want one? Okay.
You want one? Okay.
That's fine.
Okay. Well, maybe we'll, I hate to put it out that far, but I don't want to keep calling cases that there's no reason to. Should I put it all the way out to October 21? I mean, he's being held on these probation matters with no release. If it goes far enough where we need to extend his probation, we can. But a lot of it really depends upon the trial.
Exactly.
So why don't we continue both of these to October 21. Any objection to that?
No.
Okay. If something changes, then either one of you can get with the assignment clerk and we'll schedule a hearing sooner, and we can do a hearing, or we can address bond if there's some change in what's going on there, or whatever. But just so that we're not continuing to call a case unnecessarily, we'll continue this to October 21st at 3 p.m.
And I did call over there and verify they were supposed to zoom in, so I'm not sure what happened here. I didn't make sure they had the rep.
Do they have the memo of there was a change because nothing stays simple, where the Polycom domain number for calling into courts have changed all around the state.
Okay.
So like if they're putting in the old number, it won't go anywhere.
Oh, I didn't know that.
Got this phone calling back in. All right, that'll take care of Gillette.
Well, that concludes my matter, Your Honor.
Okay, you work very good.
Thank you. You too.
Same phone. Let's get to start. I'm guessing that this is going to be Mr. Appleford. All right, up next, we have People v. Robert Appleford, file 24-6930FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Blaine County Prosecutor.
Attorney Sodium Panainte for defendant Robert Appleford.
All right, good afternoon, and Mr. Appleford is appearing by Zoom from a location separate from his attorney. Let me know if we need to create a breakout room for you at any time. We're scheduled for a docket call, and also I know I just signed this yesterday, but we did want to address, rather than do any kind of warrant, a show cause for alleged bond violations. So Mr. Penanti, any objection to my, I'm intending not to cancel Mr. Appleford's bond, but any objection to my arraigning him on that contempt allegation?
None, Your Honor. And if I may have a brief resolution of all matters today. If I may briefly just inquire of the Prosecutor Goodrich. Prosecutor Goodrich, is the last agreement that we entered or that we had accepted but changed our mind on the record still available to us?
Yes.
Okay. Then we're ready to proceed, Your Honor. We'll be entering a plea to the show cause, and we'll also be entering a plea to the prior plea agreement that was previously submitted as accepted by my office. We'll be doing that today with the court's permission.
Is that the one dated April 16th, 2025?
Is that the one with low end?
Yes.
Okay.
Yes.
Well, I have a copy of that.
Okay. Do you have the amended or do you need that?
I think we probably need the amended.
Okay.
Yeah, because we didn't file them.
Thank you.
I guess we can go forward with that. On the show cause, Mr. Penanti, I'll maybe help out a little bit in that regard. I did that and can arraign him on it just to kind of track it. But when I reviewed that, that's a bond condition violation for which the complaining witness appears to bear as much responsibility as the defendant. And so I would not require Mr. Appleford to enter a plea to that contempt today. I can arraign him on it and we'll continue it to the sentencing hearing. And if there's no further problems between now and sentencing, it'd be my intention to dismiss the contempt. I assume that you and he would have no objection to that.
No, Your Honor, that would be fantastic. Thank you.
All right, so Mr. Appleford, the plea agreement that's in front of me is to an amended count 1, attempted domestic violence 3rd offense, with a dismissal of the habitual offender 4th, and a sentence agreement that any incarceration would be on the lowest end of the sentencing guidelines, however they happen to be scored at the sentencing. Do you wish to accept that plea, Mr. Appleford?
Yes, Your Honor.
Would you raise your right hand for me, sir? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay, you can put your hand down. Mr. Appleford, if you have any questions, go ahead and ask me. If you need to talk to your attorney, just let me know. I can create a breakout room for you at any time. The charge of attempted domestic violence 3rd offense would still be a 5-year punishable by a maximum of 5 years in prison and or a $5,000 fine. The attempt would reduce the guidelines range and the grid of what it would be on, but it's still a 5-year felony or $5,000 fine. Do you understand the maximum penalty under law for that offense?
Yes, Your Honor.
Do you understand if you plead guilty, you will not have a trial and you'll be giving up the rights that you would have had at trial?
Yes, Your Honor.
I want to remind you of the more important of those rights. You would have the right to trial by a judge or jury, and at that trial to be presumed innocent unless and until the prosecutor proved your guilt beyond a reasonable doubt. You would have the right to have the witnesses against you appear and to question them. You would have the right to present witnesses in your own defense and have me order them to show up. You would have the right to testify in your own defense at trial or to remain silent and not have your silence used against you in any way. Do you understand those rights?
Yes, Your Honor.
Do you wish to give up those rights and enter a plea here today?
Yes, Your Honor.
If I accept your plea, you give up any claim that it was caused by promises outside the plea agreement or by threats or any other inducements. Do you understand that?
Yes, Your Honor.
Also, when you plead guilty, you lose the right to appeal. And if you wanted to appeal, you'd have to seek permission, which you would do by filing an application for leave to appeal. The types of issues that you could raise on any appeal by application, however, are very limited. They're much more limited than if you were convicted, say, after a trial. Do you understand that?
Yes, Your Honor.
The plea agreement provides in exchange for your plea to the attempted domestic violence third, the prosecutor will dismiss the habitual fourth notice, and there's a sentence agreement for any incarceration will be on the lowest end of the sentencing guidelines. Do you understand the terms of that plea agreement?
Yes, Your Honor.
That sentence agreement for the low end of the guidelines is not binding on me. If I didn't want to follow it, I wouldn't have to. But if I did not follow it, you'd be allowed to withdraw your plea, not having received what you bargained for. Do you understand that?
Yes, Your Honor.
There is an important exception to that rule. If you engage in any misconduct between now and the sentencing, let's say by absconding, not showing up for court, violating your bond, or committing a new crime, by that kind of misconduct, you would lose the right to withdraw the plea, even if I didn't follow the sentence agreement. Do you understand this?
Yes, Your Honor, I do.
Other than the plea agreement, has anybody promised you anything to get you plead guilty?
No, Your Honor.
Has anybody threatened you to do so?
No, Your Honor.
Is it your own free choice to enter that plea?
Yes, Your Honor.
Knowing all this, how do you wish to plead to the charge of attempted domestic violence third offense?
Guilty.
Okay, Ms. Goodrich, do you have the amended information, or you'll file that later?
I'll file that later, working on it right now.
Any objection, Mr. Penanti, to the later filing of the amended information?
No objection, Your Honor.
Would you assist with establishing a factual basis for me?
Yes, Your Honor. Hi, Robert. So, give me 1 second to pull up my information here. Okay, so you are Robert Appleford, correct?
Yes.
And were you in the county of Sheboygan on or about September 23rd, 2024?
Yes.
Specifically, also in the city township village of Sheboygan, correct?
Yes.
And who is Stacy Lynn Appleford to you?
She is my ex-wife.
So fair to say you lived together at some point, correct?
Yes. Yes.
Is it true that on or about September 23rd, 2024, excuse me, you committed an assault, attempted to commit an assault or an assaulted battery upon Stacy Lynn Appleford?
Yes.
And what exactly did you do that makes you guilty of that?
We were in an argument and I swung at her and missed.
Okay. And you did this of your own choice?
Yes.
Nobody forced you to do that?
No.
And in terms of this plea agreement, you're doing this of your own choice as well?
Yes.
And you're entering this plea because you would agree, based off that, you are guilty, correct?
Correct.
Your Honor, I believe I've established a factual basis for the court to accept the plea.
Okay, and Mr. Appleford, did you have previous convictions for domestic assault in 2016 and 2019, making this a third offense?
I believe so, yes.
And I have received the amended information. So Mr. Penanti, do you agree that the court can accept that to facilitate the plea?
Yes, Your Honor.
Do you or your client wish to have it read into the record?
No, Your Honor, we waive reading of it in the record.
All right, Ms. Goodrich, do you agree that there's been a factual basis established?
Yes.
Mr. Penanti, are you aware of any other promises, threats, or inducements?
No, Your Honor.
And in your judgment, do you believe that I have complied fully with the requirements of MCR 6.302?
To the best of my judgment, yes.
Ms. Goodrich, do you agree on both counts?
Yes.
Mr. Appleford, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe you're guilty of that offense, so I hereby accept your plea. I'll schedule sentencing for August 12th at 3:20 in the afternoon. It'll be in person for you and your lawyer. You'll have to cooperate with a pre-sentence interview, so contact the probation office right away to schedule that interview so they can write a report for me. Any objection to continuation of bond, Ms. Goodrich?
No objection.
We'll continue bond. And Mr. Appleford, it's also alleged that you're in contempt of court by violating the conditions of your bond by having contact with the victim multiple times. You have the right to have a hearing on those allegations where they would need to be proven beyond a reasonable doubt, the right to the assistance of your lawyer at that hearing. If I find you to be in contempt, I could jail you for up to 93 days and or fine you for up to $7,500. You would have the right to present witnesses in your own defense and cross-examine any of the witnesses presented against you. At this point, I'll enter a plea of not guilty on your behalf to that allegation. As I told your lawyer, I'll schedule this for a status conference on that contempt for the sentencing hearing. And because I think you and the complaining witness were equally involved in those contacts, I am not going to revoke your bond at this time, Mr. Appleford. And as long as there's no contact with you, between you and her, between now and the sentencing, it'd be my intention to dismiss that contempt. But understand, as we just went over, if you violate that condition between now and the sentencing, not only are you subject to this contempt, but you would have jeopardized that sentence agreement for a low-end sentence by that misconduct. Do you understand that or have any questions for me, Mr. Appleford?
No, Your Honor, I fully understand.
Okay, anything further from the people?
No, Your Honor, thank you.
Anything further from the defense?
Yes, Your Honor, I'd request to be present for a pre-sentence interview. It's to be conducted. I'm not sure if the court ordered one to be done, but I'd like to be present for it if possible.
Yes, that's absolutely you and your client's right. I guess I would ask you to communicate to our Sheboygan Probation Parole Office right away and let them know that you do wish to be present and in what manner you wish to be present and how they're able to facilitate that. And if they're very cooperative with that. If you run into any problems with that, you can of course notify the court.
Thank you, Your Honor. And one last question. What was the time for the sentencing? I wrote down August 12th.
3:20 in the afternoon.
Thank you.
All right, Mr. Appleford, Mr. Penanti, you have a good day.
Thank you, Your
very
Honor.
much.
So I'll take it off the trial docket. Oh, here's that. Mr. Van, what case are you here on? Oh, you're on that too. Okay. All right, I've got a couple other things to take care of here first before we get into that. Mr. Freeze, are you present? You want to come on up to sit at council table here? Your lawyer is appearing by, is your lawyer Mr. Keefe? O'Keefe? O'Keefe. Let me bring in Mr. O'Keefe.
I got a couple documents I'd like to give you guys.
Well, hold up. We'll have you given to the bailiff if it's necessary. All right, Mr. O'Keefe, can you see and hear us?
Yes, Your Honor. Good afternoon.
Good afternoon. This is Daniel Freeze versus Secretary of State, file 25-9119AL. Counsel, you want to place your appearances on the record, beginning with petitioner?
Melissa Goodrich, Wayne County Prosecutor.
You're not the petitioner.
Oh, sorry. Habit.
Patrick, she's used to being the plaintiff. Patrick O'Keefe, on behalf of Mr. Freeze, the petitioner in this matter.
All right, and Ms. Goodrich, you're here representing the Secretary's interests?
Yes.
All right, Mr. Freeze, and we have Mr. Freeze present in the courtroom as well. Welcome, sir. Mr. O'Keefe, I've had a chance to review your brief and the record prepared by the Secretary of State on your appeal. Go ahead with any argument you wish to make.
Your Honor, simply stated, I'm just asking the court to give Mr. Freeze a restricted license with the ignition interlock device to give him a chance to prove himself. He's a 57-year-old grandfather. He works in construction. His driver's license has been revoked since October of 2005. So he's been revoked for about almost 20 years now. He started going to outpatient treatment at Harbor Hall back in August of 2024. It's my understanding he's still going. This matter has quite an extensive procedural history in the administrative level. beginning back in 2018 when he applied for driving privileges. The hearing officer at that point had mentioned his extensive criminal history and essentially said that his character letters were not quite good enough. In 2022, he had another hearing where he appeared before hearing officer Modelski. Hearing officer Modelski mentioned the petitioner's extensive criminal history, and he also criticized the petitioner because his assessment did not indicate whether substance abuse disorders were moderate or severe. So essentially, Officer Modelski held that the petitioner's assessment was not good enough. Then in 2025, just this past January, petitioner appeared in front of hearing officer Karen Phillips. Officer Phillips mentioned the petitioner's extensive criminal history, and she had essentially stated that he had submitted an insufficient drug test panel, that he had not submitted to a 12-panel drug screen. She also mentioned discrepancies amongst the character witnesses as to the petitioner's date of last use. I think the petitioner said his date of last use of alcohol was around July 4th, 2014. And I believe his stepfather had said that he believed that it dated as far back as 2013. So although that's a discrepancy, I think the court is well aware that witnesses hear and remember things differently, and they're told that every time the credibility instruction comes out at any trial. So they also indicate that Officer Phillips did indicate in the January hearing that the substance abuse assessment was lacking in detail regarding the petitioner's criminal history, which is impressive since the Department of State has known for quite a long time that the petitioner has and did have an extensive criminal history rooted in his addiction and his drug problem, which he did significant prison time for. None of these hearing officers have mentioned the petitioner's extended period of abstinence since 2014. He has not one single conviction, nor does he have one single traffic ticket since he was released from prison back in right around 2013 or 2014. He has grandchildren now. His last conviction for drugs was in 2011. I believe he testified at the hearing that he served 3 years in prison before he was released on parole. He was candid about his relapse back in July 4th of 2014. He indicated that he had relapsed, but the evidence clearly shows that he was abstinent. So it just seems like no matter what evidence Mr. Freese produces to the Department of State, they've always found a way, or they've gone out of their way to deny him so much as just giving him a chance and giving him a restricted license. So we're asking the court to do just that, Your Honor.
Thank you, Mr. O'Keefe. Ms. Goodrich, any argument?
Yes, Your Honor. Mr. O'Keefe did a well-written motion and brief. However, the concerns are here is the lengthy history of addiction as reflected in his criminal history. He was previously denied on appeals in 2018 and 2022. And then this appeal, he had inconsistent reports of last use history. He took the time to submit the PSI with his criminal history to the panel, but failed to list 7 prior convictions in the substance abuse assessment, which is important when giving a full assessment of the substance abuse issues. Also, the letters of support, after being told both in 2018 and 2022 on what to do, he still did not have the support letters address last use dates. Most concerning, Your Honor, here I think is the drug screen. You have to submit one drug screen. As pointed out in the Secretary of State order, that there's specific instructions on what type of drug screen that you need. It's clearly laid out, and yet that still wasn't done. The inability to follow the rules of the appeal, I think, show a disregard for the importance of the privilege of driving. So the fear is here that if he has such a careless disregard the third time appealing, then how will he be as a driver following the rules?
Great, thank you. Any rebuttal argument, Mr. O'Keefe?
Yes, Your Honor. I would just also add the fact that Mr. Freeze works in construction. He travels extensively. He's actually building a house for a friend of mine at the moment. And I find it impressive. I don't think I've ever seen somebody who's been revoked this long, who's never been ticketed for a driving offense. He gets a ride every day to work. It is particularly onerous on him as well as his company, given all the travel that he must do. They're building my friend's house up in Charlevoix. He travels all over Northwest Michigan to perform his job. And if you notice one thing, he's doing this alone. He's in 2018, 2022, 2025. Each and every one of his petitions was done pro se. So not that you have to have an attorney for these types of matters, but oftentimes when people hire me to handle driver's license appeals or DAAD hearings, I will give the people who are writing letters guidelines on what sorts of things to say, what sorts of things that the hearing officer will be looking for, such as the date of last use. So a lot of times you have people that say things, speak in platitudes or superlatives. Well, Mr. Freeze is a great guy. I think he deserves to have his license back, which, that doesn't move the needle. So, it's no secret that he is an addict. And he's been an addict since, he's been in recovery since 2014. There's been no indication that he's used any alcohol or any drugs. So, it's like, at what point does an addict deserve a second chance? And I think the answer is when that person has demonstrated that they have control of their problem. And I believe he's done that. As I said, he's been going to Harbor Hall outpatient since August of 2024. I believe he's taking the sobriety very seriously. He hasn't committed so much as a scofflaw offense. He hasn't gotten a DWLS. He hasn't gotten a traffic ticket. He's been abiding by the law. He's been a law-abiding citizen and hasn't been in trouble in over 10 years. So, in fact, probably closer almost to 15 years, because his last conviction for drugs was in 2011. And also, the court, if the court wants to, the court can order drug testing periodically to ensure that he is in fact clean. But the Secretary of State does not have that ability. All they can do is put a blow and go in his car, which is impressive since they're so concerned about controlled substances, and yet the machine that they'll often put in people's car doesn't detect those sorts of things. It only detects alcohol. So based on that, Your Honor, I'm just asking for the court to just give him a chance, let him prove himself, and then he can go back to the Secretary of State at some point in the future. And if he wants, he can ask for full driving privileges. But I think this man deserves it. Thank you.
Thank you, Mr. O'Keefe. Well, in this case, the court's review is limited to the record and reviewing that sort of as an appellate posture and determining whether the Secretary's decision to deny Mr. Freeze driving privileges, even in a restricted fashion, was supported by competent material and substantial evidence on the whole record, or whether it was arbitrary, capricious, or clearly an abuse or unwarranted exercise of discretion. In this case, there are some facts kind of trending both ways. Mr. Freeze was told in the past, here's what we need your letters to say. And then he keeps going back and they don't quite say that thing. And then he does submit a drug test that's not quite the one that they want to have. There would be circumstances, no, hang on, it's not really where you get to kind of give me information about that. There would be some situations where I would affirm a denial under those circumstances. But here, I don't think that there's really any concern that Mr. Freeze was attempting to, for example, evade the detection of a particular substance by the submission of that test. I think what was apparent to me as I went through the record, that he just wasn't doing a good job at doing the appeal the way that the hearing officers wanted him to do it. That's certainly on him, and he's responsible for that. But I do worry whether the hearing officers denied the license because there's insufficient proof that Mr. Freeze's substance abuse problems are under control and likely to remain that way, or did they deny the license because they're frustrated that he's not following their rules? Especially when it comes to those letters, I'm oftentimes baffled by the secretary's position with regard to these letters. Presiding over a treatment court myself, I know that oftentimes as part of somebody's recovery, we tell them the importance of changing the people, places, and things that they frequent. And we don't want them hanging around the people that they used or drank with. And then when they get in front of the Secretary of State, they want somebody to be able to swear and attest to the very moment that they took their last drink. I don't want Mr. Freeze hanging out with those folks and getting letters from those folks. And so that's always a bit baffling to me when people are faulted for not getting letters that can pinpoint the moment in time. More important than pinpointing the moment in time is documenting that when Mr. Freeze tells us he hasn't drank in over a decade and used in over a decade, that he's telling us the truth. And I think he did submit letters that would be sufficient to any reasonable hearing officer's mind that he was telling us the truth about that. But I mean, on the other hand, you know, they tell him you got to do these things and he's not doing the things. So I think under these circumstances, the petitioner's request for this court simply to order a restricted license with the interlock, I think is a measured relief. I think that it does give Mr. Freeze an opportunity to establish a track record with the Secretary of State where they can feel more comfortable reviewing the matter for a full license when he's eligible for that. So I do find, for the reasons that I outlined on the record, that the complete denial of a restricted license is not supported by competent material and substantial evidence on the whole record. And therefore, I would grant your appellate relief, Mr. O'Keefe, in part, and I would grant the restricted license for all the purposes allowed under the statute with the ignition interlock device, and you can submit an order to that effect. If you want to have it reviewed by the prosecutor's office for approval as to form, that might expedite its entry so that you can get that going with the Secretary of State.
Yes, Your Honor. Thank you very much.
Okay, thank you, Mr. O'Keefe. Have a good day, Mr. Freeze.
Thank you, Your Honor.
Have a good day.
You too. Sorry, I've got a couple other matters we're wrapping up here. Mr. Anthony, are you there?
I am. I'm trying to figure out, for some reason, my camera's showing off.
Okay, what case are you here on?
Set aside convictions on Brett Hillary.
Oh, that's right. Okay. Let me try to give you a notification. There we go. No, it keeps turning off. Is Mr. Hillary there present with you?
Yes, sir.
And last time I had disclosed my involvement in his prosecution of the case that he is seeking to have set aside. Have you had time to review that with Mr. Hillary and determine whether you want a different judge?
We have, Your Honor, and I called the court earlier, I think it was late last week, and advised the court that we were willing to proceed with Your Honor.
Okay. We probably do need to have the camera on then so he can offer some testimony.
It keeps kicking off. I don't know why. Let's start.
Do you want, how about I remove you from the hearing and have you zoom back in and see if that helps?
Okay.
All right, is there a Ryan Laway present? He is not present. We had a petition noticed up for today for a restricted license, hardship license, and a first implied consent suspension. Mr. Laway is not present, has not zoomed in. Rather than denying it, I'll treat that motion as, well, there are time limits for that.
Yes.
You wouldn't need it for this. Any objection? Am I treating it as withdrawn until renoticed? And then if it's renoticed, you can raise any timeliness objections you want at that time.
No objection to that.
Okay, we'll treat the motion as withdrawn until renoticed. Try here. All right, there we go. That's working. All right, there we go. You seem to be working on our end.
There I.
And it turned off. It worked and then it turned off. Well, we got a couple different options.
Let's hope it stays on.
Okay.
There we go.
All right, and so we've got People v. Brett Hillary, file 2010-4215FH. Mr. Hillary is appearing with his attorney, Mr. Anthony, from Zoom in the location where they are together. And we have got the prosecuting attorney, Ms. Goodrich, present in the courtroom. So time and date set for a petition to set aside some convictions. And Mr. Anthony, before we take testimony from your client, I did receive a letter from the Attorney General indicating that because these are assaultive crimes, he may have 2 of them set aside, but not all 3. Do you have any legal argument with that position?
I do, Your Honor, and I'm citing MCL 780.621B that says set aside a conviction under Section 1, more than 1 felony offense, must be treated as a single felony or misdemeanor if the convictions were contemporaneous, such that all the felony or misdemeanor offenses occurred within 24 hours. And that was the case here. And then I do think we lost the camera. We lost the camera again. Constitute any of the following. And I understand the courts. Oh, come on.
All right. Well, we are having technical issues with the camera, Ms. Goodrich and Mr. Anthony. Let me ask you, it was working long enough that I know that is Mr. Hillary with you. If neither one of you object, we can proceed with audio conferencing for this hearing. Ms. Goodrich, do you have any opinion about that?
No objection to that, Your Honor.
Mr. Anthony, any objection to proceeding with your audio only? I saw that Mr. Hillary was the one with you.
No objection, Your Honor.
Okay, so go ahead and continue with your argument. You're arguing that this was fits under what was colloquially called the 1 bad night provision, so that I can count all 3 of those as 1 conviction?
Yes.
Okay. Ms. Goodrich, do you have any response to that legal argument?
Your Honor, I don't have access to the police report. I'd have to take Mr. Anthony's word that this did all happen in 1 consecutive time.
And as I disclosed last time, I had been the one to issue the complaint and warrant and authorize the charges in this case, but then did not participate in the trial. So I didn't think I was although I was personally involved in the prosecution, I didn't believe I was substantially involved in the prosecution. And Mr. Hillary indicated he had no objection to my presiding over his motion to set it aside. I do have enough of a recollection that I do recall that this did all happen contemporaneously, so I would treat them as having occurred within the same 24-hour period. So with that, I do think he's eligible to have all three set aside if he does meet the requirements for his behavior. So Mr. Hillary, from where you are, would you raise your right hand? And do you swear to tell the truth, the whole truth, and nothing but the truth? So help you God, sir.
Yes, Your Honor.
Okay, Mr. Anthony, go ahead and question your client to establish anything you want on the record.
Say your full name for the record, sir.
Brett, B-R-E-T-T, middle name Clinton, C-L-I-N-T-O-N, Hillary, H-I-L-L-E-A-R-Y.
Your date of birth?
29 April 87.
You were convicted back in 2012, is that correct?
I believe so.
That was a jury trial?
Yes.
And that resulted in 3 convictions against you, right?
Correct.
Since that time, have you had any other criminal activity, criminal convictions?
Negative.
And so you're telling this court under oath that you've not been charged or convicted of any other criminal activities?
That is correct.
Since that time, have you been gainfully employed until recently?
That is correct.
And my understanding is for the last 3 years, you're disabled?
That is correct.
And you filed a disability claim through workers' comp, and from what you understand, you're likely to be declared permanently disabled?
That is correct.
And you've had back surgery?
That is correct.
You have 3 back, what they call cages on your spine?
I have had 3 fusions, 8 pins, and through lower lumbar 2 through 5.
And so my understanding is that you're not capable of work and you're under constant pain. Is that correct?
That is correct.
Do you have a son?
Yes.
And can you tell us if your son has any special needs?
My son is autistic.
And have you been raising him with help from your mother?
Yes.
How old is your son?
Shoot. 18 years, going on 19, August 12th.
Okay. And so you've been the sole care provider for him along with your mother?
Yes.
And sir, if you have to stand, please feel free to do so. I know your back bothers you. And you're under constant doctor supervision now?
Yes.
Taking pain pills?
Yes.
So would it be fair to say that since that time, can you tell the court just briefly your employment history since 2012?
Let's see. I worked fast food in Flint. Went from Flint to Wheeler, Michigan. Had nothing in Wheeler. Went from Wheeler to Isabella County. Worked at landscaping, fast food, and everything else. Later on in the years, I worked as a 2013 or 14, there, give or take, somewhere on the route. I was a lighting technician only up till 2019. Got laid off. Then I worked for this company, ABC Warehouse in Mount Pleasant, and destroyed my back for that company.
And that was a lifting problem that created your back issues, is that correct?
That is correct.
And so ABC was the last place you worked?
That is correct.
And on the lighting technician, you were laid off, is that correct?
They shut down the electrical side, that is correct.
All right. And basically you were going into stores and working on converting the lights from LED to
fluorescence to LED, that is correct.
And so, like you said, at this stage, there are no criminal activities or anything pending against you?
That is correct.
More than 10 years have elapsed since the time you were convicted?
That is correct.
And basically, it would be fair to say you've been the model citizen?
Yeah, fair to say, I'll agree.
And at this stage, basically, your existence is day-to-day in pain management?
Yes.
Court have any questions of my witness, Your Honor?
I have none. Ms. Goodrich, do you have any cross-exam?
I do not.
Okay, there being no cross-examination, Mr. Anthony, any argument?
I would just say, Your Honor, that this is one bad night. Since that time, he's led an exemplary life. He'd still be working full-time, except for his workers' comp injury. Like I said, he's in constant pain. That's pending before the comp courts. I think that he'll be given an award there. So I don't think he's going to be a burden on society, because I do think that's going to be successful. That was referred out to another law firm. Otherwise, I'd have more information on that. And like I said, more than 10 years, he's done all he could to keep his nose clean and be a model citizen, help raise his son. He's the sole provider for him, along with help with his mother. So I'd ask the court to exercise its equity powers and set aside all 3 convictions.
Ms. Goodrich, any position from the people?
Yes, Your Honor, our victim advocate did reach out to the victims, left voicemails, and that was prior to the last hearing. We still have not heard back from them. No return calls. So I do support the petition.
All right, thank you. Well, Mr. Hillary, I do find, based upon my review of the file and your testimony here today and the argument of your attorney, that you have not been convicted of more than 3 felonies. You've not had any convictions for an assault of crime previously set aside. There are no criminal charges pending against you. You've not been convicted of any criminal offense during the applicable time period under the statute. That you've not previously had a felony conviction of more than 10 years imprisonment set aside. I find that the time period for all the convictions listed in your petition have passed. I also find under paragraph 11 that all 3 of those convictions occurred within 24 hours and arose from the same transaction pursuant to MCL 780.621B. An opportunity has been given to the Attorney General and prosecuting official to contest the application. And based upon your testimony here today, I do find that the circumstances and behavior of the applicant from the date of the conviction to the filing of the application warrant setting aside these convictions, and that doing so is consistent with the public welfare. So, Mr. Hillary, I'm going to grant your petition and set aside all 3 of these felony convictions for you. And Mr. Anthony, you can prepare and submit an order to that effect.
Thank you, Your Honor.
Thank you.
I appreciate the court allowing us to appear by Zoom, and I apologize for the video mishap. I don't know what's going on.
Okay, that's all right. You have a good day.
Thank you, sir.
So my apologies. That does bring us now finally to People v. Christa Wy person. And, this is file 23-6723FH. We have 2 things scheduled today. One is a motion to correct a sentence. We also have a probation violation hearing. Counsel, would you please state your appearances beginning with People?
Melissa Goodrich, Wayne County Prosecutor.
No, and I go for Miss Wiley Percy, who does go by Miss Wiley. Just
Daniela Cohen, on behalf of the State Appellate Defender Office. Good afternoon, Your Honor. Jacqueline McCann from Sato for Ms. Percy as well.
Okay. All right. And which makes sense to hear first? The violation hearing? Okay.
I think it makes sense to do the violation hearing first.
Okay. All right. And so any opening statement that you wish to make, Ms. Goodrich?
No, Your Honor.
Mr. Nightingale?
No.
Any witnesses, Ms. Goodrich?
Yes, I have Deputy Mackenzie Collins on Zoom.
Any objection to Zoom testimony?
No.
All right, Deputy Collins, if you can unmute yourself and raise your right hand for me. Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You can put your hand down. Go ahead, Ms. Goodrich.
Thank you. Can you start by stating your name for the record, please?
Mackenzie Collins.
And where are you employed?
Through the Humane Society of Sheboygan. I'm deputized through the Sheriff's Department.
Thank you. And how many years have you been in that position?
5 years.
And without stating the address, are you familiar with Christa Wy's residence?
Yes.
And did you accompany MDOC agent Leslie Martin to Christa Wy's residence on March 19th of 2025?
Yes.
And during that visit to Christa Wy's residence, did you observe any animals?
Yes.
And what animals were there?
I believe there was definitely fowl. I want to say there was some geese, and a few chickens. I'm not sure if it was roosters or hens. I was unable to see because they were in the back of the property. And I'm not sure the exact amount, either.
Okay. And on May 20th of 2024, did you communicate with MDOC agent Leslie Martin about additional animals? Oh, I'm sorry, that was prior. Did you advise her what animals were taken from the property?
Yes.
And at that time, had you removed all birds except for 7 chickens and geese?
That is correct.
And just for clarification, these geese were farm geese, not just geese that happened to fly there at the time that you were there?
Correct. They were domesticated.
And since that time of reporting that on May 20th of 2024, you did not forfeit any remaining chickens, or she did not forfeit any remaining chickens or geese to animal control, Christa Wy.
Correct.
Thank you. No further questions.
Cross-exam?
Yes, sir. Thank you. Deputy Collins, you said you worked for Animal Control for about 5 years. Is that right?
That is correct.
Okay. And Ms. Goodrich asked you just earlier, she said that, or asked you that if you went to Miss Riley's home on May 14th of 2024 or right after that date to go remove some animals from the house. Is that correct?
I believe it was May 19th that we stopped at the residence.
Okay. Were you only there one time?
No, we were there multiple times to remove multiple animals.
And that was in May of 2024, right?
Correct.
Okay. Would you say that you were there probably 4 times that week removing all the animals?
Truthfully, I'd have to look back. I'm not sure exactly. Around there, yes. Around that amount, yeah.
Okay. Fair to say that this was a pretty large operation and was not able to be completed in one single day. Is that fair to say?
Correct.
Okay. And some of the animals that you removed were like horses and a donkey and an emu, those kinds of animals, right?
Correct.
And after your last visit to Miss Wiley's home, it was just the geese and maybe some chickens that were left. Is that right?
Correct.
Between May of 2024 and March of 2025, did you ever return to the home to remove any more animals from Miss Wiley's house?
I believe in May. May I look at previous report?
I'm sorry, I didn't hear the last thing that you just said.
May I look at my report?
Would it help to refresh your recollection if you looked at that report?
Yes.
I have no objection for doing that.
Okay, go ahead.
Can you please repeat the question?
Sure. Between May of 2024 and March of 2025, Did you ever go back to Miss Wiley's house to remove any additional animals?
I don't believe so, no.
Okay. And just to go back a little bit, I think probably 4 times that you were there in May of 2024 to remove the vast majority of these animals. Was Miss Wiley cooperative with you when you were doing that?
Yes, she was cooperative at the beginning, yes.
Okay. And do you remember her actually assisting you in loading the horses and I believe at least the emu into their livestock pens in order to be transported to animal control?
Yes, yep.
Okay. And so she actively actually helped you to load these animals. Is that fair to say?
Yes, the first day that we were there to seize the majority of them, she was helpful, yes.
I don't have any further questions for this.
Any redirect?
No, Your Honor.
Deputy Collins, I have a follow-up question. After you were finished in May of 2024, removing all the animals except for, says some chickens and geese, did you leave any instructions for Miss Wiley about what you wanted her to do regarding the remaining animals?
Yes, so the previous probation officer, I believe first name Kristen, she was told that she was going to have Christa catch the remaining birds as we caught all the other ones. And she was responsible in catching the remaining ones and turning them over to us.
Okay. All right, any follow-up questions as a result of the court's question, Ms. Goodrich?
No, Your Honor, thank you.
Mr. Nightingale?
No, Your Honor, thank you.
All right, Deputy Collins, thank you. You're excused from further testimony here.
Thank you. Have a good day.
Ms. Goodrich, any additional witnesses?
Yes, I'd like to call MDOC Agent Leslie Martin, please.
Okay, Agent Martin, if you please come on to the witness stand as you arrive, raise your right hand for me. Just swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Okay, you be seated.
Can you state your name for the record, please?
Leslie Martin
And where are you employed?
with the Michigan Department of Corrections,
And what is your position?
probation and parole officer,
Okay, and how long have you served in that capacity?
over 22 years.
Thank you. And do you have Christa Wy on your caseload?
Yes, I do.
And when did you take over her case?
November 1st of 2024.
And on March 21st of 2025, did you file a request and summons for probation violation?
Yes, I did.
And did you allege contrary to special condition 9(1) a violation of that condition?
Yes.
And what was the violation?
Christa still has animals, farm geese, chickens, hens, and a rooster on her property, and she's not to be in possession of any animals.
Okay, and how did you come about learning that she still had possession of animals she wasn't supposed to have?
As a result of anonymous tips, I did a compliance check with animal control on March 19th and viewed 9 farm geese and heard at least 1 rooster on the property. And then on March 20th, Christa reported to the probation office, at which time she admitted to having 9 farm geese, a hen, a rooster, and 13 chicks on her property.
Okay. And you also alleged a violation of special condition 902. What was the basis for that?
The condition that she must cooperate with animal control for the forfeiture of the removal of all the animals except for the 1 service dog.
Okay.
Per review of the case notes on March 20th, there was communication between Deputy Collins and the supervising probation officer at the time that there was all the animals were removed from the property except for 7 chickens and the geese. And for review of the case notes, since that time, there was no further communication that those animals had been turned over to animal control.
And that communication was via text, is that correct?
Yes.
And since filing this violation on March 21st of 2025, has Christa Wy taken any action to forfeit the additional animals on her property?
Not that I'm aware of.
Thank you. No further questions.
Cross-examine?
Yes, please. Thank you. Good afternoon, Agent Martin. So just to be clear, you did not start off as Ms. Wiley's probation officer, is that right?
That's correct.
Okay. It was Agent Dudek, I think, that had her before, is that right?
Yes.
So basically anything that occurred before November of 2024, you had no personal involvement in. Is that fair to say?
Yes.
But you have been able to review the notes in the file, right?
Right.
Now, you did not go to the home in May of 2024 because you were not her supervising officer, right?
Correct.
But you did go to the home in March of 2025 because at that point you had taken her.
Yes.
And at that time, you personally observed these 9 farm geese and then heard a rooster on the property, right?
Correct.
Did you have a meeting scheduled with Ms. Wiley already on March 20th, or is that something that you called her in for?
No, I believe I called her in for that.
Okay. And so she appears for that appointment with you, right?
Yes.
And she discloses to you exactly what's on the property, right?
Correct.
Since that disclosure, have you, or to your knowledge, animal control gone back to the house or the property to remove these animals?
I have not, because I don't remove animals from property, and I'm not aware of animal control removing any animals since that time.
Okay. Did animal control contact you to advise that they had tried to go and were not able to get the animals?
Since when?
Since, good question, since March of 25.
Not that I'm aware of, no. They have not attempted to remove the animals and notified me of that attempt.
And as you said, obviously it's not your job to remove animals, right?
Right.
I have no further questions for her.
Any redirect?
No, Your Honor.
Kate Martin, thank you. Step down. Any additional proofs?
No additional proofs.
Any defense proofs?
Judge, I would call Ms. Wiley this time, please. Is it okay she sits here since she has her service animal with her, or
That's fine.
Corporate for her?
I can go there.
No, that's fine.
Okay.
Right there is fine. If you want to stand and raise your right hand for me. Just swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Can you be seated? Go ahead.
Thank you, Judge. Ms. Wiley, can you state and spell your name for the record, please?
Christa Wy, Krista Wiley.
Okay, in the court record, you're noted as Wiley Percy, but you go by Wiley, right?
Correct.
Okay. And how old are you today?
41.
Now, Ms. Wiley, you were placed on probation out of this court May of 2024, is that right?
Yes.
And you were put on 5 years of supervised probation, right?
Yes.
And you had some pretty special conditions that you were to abide by, right?
Yes.
And you know, these conditions were gone over with you as a part of your probation sentence, is that correct?
Correct.
And you not only had the opportunity to discuss those conditions with Agent Dudek and also Agent Martin at a certain point, but the court gave you instructions at your sentencing, is that right?
Yes.
And part of those instructions, I guess, did the court allow you to rehome these animals on your own?
No, Judge Guyire stated that the animal control would come and seize the animals.
Because you did specifically ask, right, at your sentencing, if you would be able to do that rather than relinquishing them to animal control,
Correct.
right? And so you were not given that permission to actually move these animals on your own, right?
Correct.
And so is it fair to say that you were pretty dependent on animal control to actually come get these animals?
Correct.
And they did appear, animal control did at your home 4 separate times in 2024, right?
Yes,
Do you remember the specific days of the week that they were there?
Wednesday, Thursday, Friday, and then again on Saturday.
And did you have to miss anything, any sort of personal obligations as a part of complying with these orders?
I missed work,
How many days did you miss work?
4 days.
And that was to comply with this court order, right?
Correct.
And at the end of that last day that animal control were there that Saturday, what animals were remaining at the house?
Sammy the emu, the mom and dad and the goslings, and a chicken and a rooster.
So when you say mom and dad and the goslings, you're referring to a male and a female goose, is that correct?
Correct. And goslings are babies.
Thank you. And then a couple chickens, is that what you said?
Yes.
Now, had animal control returned to your home, would you have relinquished these animals?
Yes.
But since May of 2025, they have not returned to your house, right?
May of 2024.
Sorry, May of 2020, no, 25.
No, 24.
24.
They were out there May, they were out there May of 2024 and March of 2025.
March 25. Apologies. Thank you. March of 25.
No, they have not been back.
Okay. But had they been back, you would have relinquished those animals. right?
Correct.
Now, when you said that after their last visit to the property in May of 24, May's and March are hard for me apparently, that there was these geese, a couple chickens, and the emu left. Is that right?
Correct.
And when did they come back to the emu?
Saturday.
So that was on the Saturday, the very last day they were there.
Correct.
Did you have to do anything special to help them get that emu off the property?
I had to help Deputy Collins back up her truck and trailer to load the email while she stood about 50 feet away. And I put a leash around Sandy the emu and walked him into her livestock trailer.
Did you have to do anything else like that for any of the other animals?
No.
Not like the horses or anything?
The horses, they were able to drive the truck and trailer to the back of the property. There's a road where we'd taken our hay and back it up. The horses, that was for the goats. The horses, we walked up to the road. So I put the halter and lead rope on my horses and walked them up to the roadway to help them load into the stock trailer.
And at this time, do you have any other animals on the property besides your one certified service animal?
No.
I have no further questions, Ms. White.
Cross-exam?
Yes. Ms. Wiley, where are the 9 farm beasts?
Per my appellate attorney, I removed them from the property.
And where did you put them?
I gave them away.
And when was that?
March 22nd.
Of this year?
Correct.
Okay. And where is the hen?
She is off the property too.
And where did the hen go?
I just gave them away.
And where's the rooster?
With the hen.
And how about the 13 chicks?
With the mom, which is the hen.
So when your attorney told you to get rid of the animals, you were able to do that. But when animal control and your agent told you back in May 2024, you kept them there.
They did not tell me to remove the animals. They said animal control would come back and get them.
And how often since May 2024 have you met with your agent, both the prior one and current Agent Martin?
I had Kristen Dudick. She was 2 times a month. I'm not sure how long she was. She got a job in the prison, left. Eric Young took over midstream, and then Leslie Martin took over in October.
Okay. And did you meet both with Miss Agent Young and Agent Martin 2 times per month?
For October, November, December, and then in January, it went to 1 time a month. For January, February, and March.
And did you understand that part of your conditions were that you not own, possess, or care for any animals or live on any property that has animals?
Correct. She was notified, Miss Martin was in October, that I still had the geese and the chickens on the property.
Okay, and was she notified by you on March 20th, 2025?
That was my normal report date, and yes.
But prior to that, she was not notified?
No, she was October twice, November twice, December twice, January once, February once, and then in March on my report date. She was well aware those animals were still on the property.
And you knew that that was a condition of your probation not to have those animals on your property?
Correct.
No further questions.
Any redirect?
No.
Okay, thank you. Any further defense proofs?
Defense for rest except for.
Any rebuttal proofs?
No, Your Honor.
Argument, Ms. Goodrich?
Your Honor, based on the testimony of Deputy Collins, the testimony of Agent Martin, and the testimony of Ms. Wiley, I believe that she has been in violation of Special Condition 9.01, where she was owning, possessing, carrying, and living on property with animals that was personally observed by the agent, as well as defendant has admitted to that both on March 20th and here today. And also Special Condition 9.02, that no efforts were made for her to forfeit those animals. She simply was just sitting there in violation and waiting for someone to come take it, I guess. She hasn't testified at any efforts that she made to comply with her probation, and I'd ask that she be in violation of both of those conditions. Thank you.
Thank you, Mr. Nightingale.
Thank you, Judge. So for Ms. Wiley, what I think is really clear here is that every time animal control came to her residence, she was cooperative and removed animals. She went so far as to back up their own trailer for them and to put animals in the pens for them. I don't know how much more cooperative she realistically could have been. If animal control and probation are aware that these animals are still on the property, I'm referring specifically to the geese and the couple chickens that were remaining after this May of 2024 search, those 4 different days that they were on the property removing these animals. I don't think that at that point that Miss Wiley was able to then comply with her terms of probation. That animal control was required to come get these animals. She was not just allowed to remove them, but until they filed a violation alleging that, well, she's still possessing them, but she also can't remove them. She's in like a rock and a hard place type of situation. Further, what I would say as far as Special Condition 09.01 is that this is overly broad. I would say that this is probably void for vagueness and applies in the face of due process. So it says you may not own or possess or care for any animals or live on any property that has animals except for your one certified service animal. The statute that she was convicted under defines an animal as a vertebrate other than a human being. There's no differentiation here between wild, domestic, livestock, fowl, service animals, except for her one certified animal, companion animals. There's all different definitions of what these things are under the statute. And to say that she can't live on a property that has any animals is overly broad. She's not able to comply with this or have proper notice of what she's actually supposed to do. For example, say, right, that we never had any of these allegations of probation violation. She built a giant fence around her house. She's in a full-on compound. A bird flies into her yard and she has to leave. I mean, that's kind of where we're at, right? And I don't want it to be laughable, but at a certain point, what is she to do under these circumstances? Every time they come to her house, she is cooperative. There's not a violation filed actually until the appellate attorneys get involved. They file this motion for essentially modification of her sentence is what I'm understanding. And then magically we're here for a violation. It just seems fishy. And I don't, like I said, I mean, 902 says that you must cooperate with animal control for the forfeiture and removal of all the animals. She's done that. Every time they come, she cooperates, she forfeits animals. She can't make them take additional animals. If they're not equipped to take them, they can't take them, and she waits for them to return. I guess, sorry, I have to look at my phone for just a second, but I was able to see just a snippet of the transcript from the hearing back on her sentencing. And I guess I would just ask the court to take judicial notice of that hearing.
Page 15.
Yes, thank you. That's exactly what I'm looking at, Judge. She asked, Ms. Wiley asked, may I ask you a question? The court says yes. She asked, am I able to relinquish these animals back to their previous owners? The court says, no, they're forfeited to animal control and they'll rehome them as appropriate. She says, okay. What else is she supposed to do at this point? She's been in full compliance. She is in compliance now at the advice of her appellate attorneys, not just at the advice of probation or animal control. She's done everything that she could, Judge. And so even by her preponderance standard, the people have failed to meet their burden, and the court should find her not in violation of continuing probation. Thank you.
Thank you, Ms. Gooderson. Your rebuttal argument?
But Your Honor, regardless of whether she was to forfeit them or not to animal control, she certainly got rid of them as soon as an attorney told her, but failed to, despite the felony probation terms, that she not live on property with the animals or not own, possess, or care for those animals. So I would still say that we proceed with the violations.
All right, thank you. Well, here at the sentencing back on May 14th in 2024, I stated on the record that as an additional or as a condition of probation that all the animals that you currently possess and own at that property are forfeited to the Humane Society, with the exception of your one service animal that you do have with you today. You're also, as a condition of your probation, going to have to cooperate with animal control for the removal and forfeiture of those animals. Any failure to cooperate or disclose information to them could bring it back into court on a violation of probation. She asked if she could relinquish the animals back to previous owners. I told her no, they were forfeited to animal control. They'll rehome them as appropriate. Now, the general rule, of course, is that courts speak through their written orders. In the written order of the probation order, condition 9, I mean, the easy one is 9.02. There's no proof of a violation of 9.02. That requires that she cooperate with animal control for the forfeiture and removal of all the animals except her service dog. And she did. Every time they showed up, she cooperated to do that. That placed on her the affirmative obligation only to cooperate and not interfere with their efforts. I guess I can understand that the animal control officer may be tired of chasing chickens and had to capture Sammy the emu and the donkey. And I'm sure this was quite a protracted affair and took a great deal of effort. But as a factual matter, animal control left the premises knowing that animals that were forfeited to animal control remained on the premises. I forfeited those animals to animal control. I told Miss Wiley, I'm sorry, that she couldn't do anything with those animals except give them to animal control. So she cooperated. There's no evidence of the violation of 902. 901 is a bit trickier because if I just look at the written order, you can't possess or care for animals or own them or live on property that has them. And if I look only at that language, she's violating that, to be sure, for months that she's living on. And I would hope she's feeding those animals, so she's providing some care to them. And I don't blame the probation officer has to bring this violation, gets a tip that, hey, there's animals still out there. She does a check. Yep, there's animals still out there. She's filing the violation. Probation officer did nothing wrong, and the probation officer is absolutely correct. Department of Corrections probation supervision does not include chasing chickens around the yard. So that's not their job. It is, however, animal control's job. And animal control, I'm sorry to have to say it this way, but simply did not do their job. And if I read that language, not in a vacuum of what's on the printed page, but Miss Wiley was standing in front of this court with a straddle cell where she could have gone to prison. I'm sure that's a very daunting moment in any person's life. And I'm sitting up here from this bench and telling her, those animals don't belong to you anymore. They're forfeited to animal control. no, you can't do anything else with them. If I'm her, I would be terrified to rehome those animals on my own. They come to get the animals, they leave without the animals. What is she supposed to do? I can come up with a list of things that I'm sure that we all would have wanted her to do, as her appellate attorneys advised her. Hey, under these circumstances, you're going to be okay if you get rid of those animals. So if she would have consulted with an attorney, for example, I'm sure any of us in this room would have told her, get rid of those animals on your own. But she didn't have the benefit of that, other than the animal control officer who's tired of chasing these says, well, you do this for me now. I think I can't view that language in a vacuum. Miss Wiley was, in fact, between a rock and a hard place here. I disagree with the contention that this is somehow unconstitutionally vague. Clearly she's not going to get violated for a squirrel wanders through her yard. But I do think it's clear enough in context that if she obtains or cares for any animals, or she moves somewhere and they have animals that are being cared for, domesticated or farm animals or whatever of any kind, she's going to be violated. And she knows that. I think it's clear enough. If that happens, she can raise the void for vagueness arguments at that time and we'll deal with them. But I think even setting that aside, I do not find, based on a preponderance of the evidence, that a violation has been established. I'm glad that she's cooperated with her appellate attorney's advice to remove the animals. And at this point, it appears that she is in compliance with those probation conditions. So the court will find the violation has not been proven, and I've signed an order to that effect to file with the clerk. Thank you, Mr. Nightingale, for your representation in the matter.
Thank you, Judge.
All right.
Yeah, you stay there. I will step aside and let her real attorneys take it.
All right. All right. You okay with doing the break? Okay. You can take 5 minutes if you need. Okay. All right. So now we are. All right, Ms. Cohen, you're here with your motion to correct an invalid sentence.
Yes, sir.
I've reviewed the motion and supporting materials. Go ahead.
Thank you, Your Honor. We don't want to belabor the point, but as you can tell, Ms. Wiley cares deeply about the animals, and she was very upset about this process and how everything happened. So we filed this motion not because we are trying to argue that she's not or hasn't done anything wrong. We're merely asking the court for a chance at rehabilitation when the ban on all animals, save for her service animal, was put in place. There was never any opportunity whatsoever in literally, quote, her lifetime to show the court that she could own or possess any kind of animal beyond the service dog. And so we're merely asking the court that she be able, not even today, but down the line, that she be able to prove to the court that she's capable, she's more than capable of taking good care of animals, and the court can impose whatever kind of conditions it would like on that process, or the quantity of animals or the type. But that's the basis of our motion today. We would also just join trial counsel in arguing that we do think the language itself in the probation order about this lifetime ban on all kinds of animals is overly broad, but we understand that you might disagree with that.
Can I ask you though, so here's what I struggle with, because if I only look again at, and if the appellate court looks only at the lifetime ban in conjunction with a 5-year probation? Yes. I think, again, sort of like looking at things in a vacuum or in context, as I just did in the violation. If we're only looking at 5-year probation plus lifetime ban, I think you'd have an awfully good argument that lifetime ban is unlawful, and you may very well prevail. But the statute allows for lifetime probation to facilitate that. I'm not sure that anybody is any longer a fan of lifetime probation. The state of Michigan had some experience with lifetime probation during the what we now understand to be a panic about some cocaine sentencing and things like this. And there were all sorts of lifetime probationers, which causes a terrible problem.
Sure.
So under the statute, I could have, and based on Ms. Wiley's record of animal control violations, it may well have been proportionate to give her lifetime probation to facilitate this ban. But I don't want to do that and subject her to the liberty interests if she violates this lifetime ban after probation, her maximum exposure penalty is 93 days for contempt of court. I didn't want to have her for the rest of her life have prison jeopardy over her head by a lifetime probation. So I'm trying to fashion some way to accomplish the lifetime ban without the attendant liberty constrictions on lifetime probation and fashion some mitigation. So my question to you, with all of that preface, is there a path for a court to do that? Or is that just not among the valid menu items that I can order?
Would you give me a moment to consult with my colleague?
Sure.
Can I ask you a question, Your Honor?
Sure.
Just to clarify your question.
Yeah.
Do you mean that without placing her on lifetime probation, you can't sort of give her restrictions as to what animals she might be able to own versus not own?
No, I just mean, what's my authority to impose any ban beyond the time constraints of the probationary order?
So does the lifetime quote unquote ban really a 5-year ban?
Right.
You can.
What else? I mean, okay, you're the head of the mentorship program, right?
Yes.
And are we kind of doing that?
Yes.
I have no objection. Ms. Goodrich, do you have any objection to both attorneys participating in the argument?
I don't, Your Honor.
Okay. You may both participate in here. Go
Thank
ahead.
you, Your Honor. Jacqueline McCann, for Ms. Wiley. I struggle with this in other contexts too, Your Honor. It will say lifetime electronic monitoring for the CSC offenders. I have had former clients say to me, well, they took that off after my parole ended. That's not my understanding of how it's supposed to work if you read the statute. And that's sort of the situation I'm in with your question about the lifetime ban.
Right, but there's a statute that allows lifetime electronic monitoring without regard to being under a term of supervision. This statute says I can impose a ban as a condition of probation, and probation can be lifetime. So I'm a little bit outside the statute to impose a ban that exceeds the probationary term, but I'm trying to do that to inure to the benefit of the defendant.
In order to avoid the lifetime probation.
Correct.
And if Your Honor is saying that that if lawfully there is no way to do that.
Other than lifetime probation, I would have put her on lifetime probation. So what do I do then?
But as your understanding of your existing sentence, if I'm trying to make sure I understand that, is that the lifetime ban on animals is only good for the 5 years?
No.
Okay.
No,
That
I'm
it
saying,
will- that it
I'm
will
saying
continue on.
you might win on that argument at the Court of Appeals is what I'm telling you.
Okay.
But that was an important part of my sentence. And if to facilitate that, I had to give her lifetime probation, I would have. So.
Well, let me say this, Your Honor, our other position on this, and I think it's kind of in the motion as well, is that we're asking you to let her go forward on probation and sort of defer your decision about the lifetime ban until the end of her probation cycle. And if that means Your Honor like denies this motion without prejudice to us bringing it again, you know, that seems like a possible solution.
Might really complicate your appellate argument.
Well, you know, my concern is more about what's best for Ms. Wiley, and if the real life solution is to deny it without prejudice and we can return as a motion to amend the terms, maybe that's the best thing for her.
My other question is related. When I review the sentencing transcript and refresh my recollection of those details, it seems that the severity of that lifetime ban and my appreciation of its effects on Ms. Wiley were a consideration for why I did not impose any incarceration despite a guidelines range of 12 to 48 months. So if either on this motion or on appeal, the lifetime ban is set aside, wouldn't the proper remedy be an entire resentencing, where if that's off the table, I reconsider everything else that we were talking about, the length of probation and whether there's any incarceration imposed? So by pulling on the lifetime ban thread, don't you undo the entire sentence?
It was not our intention to do that, and if Your Honor interprets it that way, I would like some time to talk to Ms. Wiley about whether she wants to go forward with this motion or not, because certainly we don't want her to be exposed to prison time.
Yeah, I think I would interpret it that way. But let me ask you as a practical matter then, would it solve this matter practically if I were to enter an order that is for the benefit of either me or any successor judge, because this is a lifetime order that's lingering out there, that the defendant may once every 5 years petition the court for relief from that provision?
That would be, I think, an excellent solution, Your Honor.
All right, anything else you want me to know to understand your position?
No, Your Honor.
Okay, Ms. Goodrich, people's position?
In light of the court's questions, I have nothing really new to add. That was my concern. I wasn't sure what was being asked. Are they saying, hey, consider incarceration because we don't like the lifetime ban? Are you looking for the any term of probation that the statute allows? Kind of one of those, be careful what you ask for. I have no objection to the court adding that every 5 years she could petition the court.
It's a very unusual order for there to be just an order that's out there that exists for the lifetime of the defendant. So given that circumstance, I would grant partial relief and would sign an order presented by the defense that would amend the judgment of sentence. We're not going to do an amended judgment, but would be a separate order that would say that once every 5 years, beginning from the date of the judgment of sentence, Ms. Wiley may petition the court for relief from that order. And it would be my position, I guess I'll just state on the record for whatever is going on up in a higher court, that if I'm well aware that the ban not within a probationary term appears on a reading of the statute to perhaps not be authorized by that statute. If that's ever a ruling, that was part and parcel of the sentence, and I think it would require a resentencing. Because I may well have imposed lifetime probation to facilitate that. And which, if I had done that, because I'm talking myself into the relief you asked me about, if she was on lifetime probation, probation is always subject to amendment. So if she was on lifetime probation, she'd always be able to come back and petition for a term to be modified. So this order allowing her to petition for relief on a periodic basis seems to be consistent with what that would be. Because what I'm trying to do is have that be a lifetime order without having her be on probation and subject to going to prison if she violates. She catches a drunk driving while she's on probation, 30 years from now goes to prison. So having said all that, I don't think the sentence is unlawful. If to the extent anybody thought so, I think the remedy would be a complete resentencing. In lieu of that, I'm going to grant the partial relief as I outlined, and Ms. McCann, you can submit an order that.
Thank you so much, Your Honor. I will draft that and run it by Ms. Goodrich and we'll get it to you.
Okay, thank you all very much for your careful attention to an unusual case.
Thank you, Your Honor.
Thank you.
And we are adjourned. All right, and we are continuing on the record in the 53rd Circuit Court for the County of Sheboygan and providing public access now, both in the courtroom and also online. And we have on our afternoon docket then People versus Jerry Jones, file 25-7023. Counsel, you want to state your appearances for the record?
Melissa Goodrich, Warren County Prosecutor.
Luke Gusky on behalf of Mr. Jones, Your Honor.
All right, good afternoon. This is the time and date set for a docket call, and also there's a show cause. Mr. Jones, it's It's alleged that you're in contempt of court for violating a condition of your bond. You have the right to have a hearing on that allegation where your contempt would need to be proven beyond a reasonable doubt. And you have the right to the assistance of your lawyer at that hearing to present evidence in your own defense and question any witnesses presented against you. If I do find you to be in contempt, I could jail you for up to 93 days or fine you up to $7,500 or both. If I believe that you're not complying with the conditions of your bond, I can revoke or amend that bond at any time as well. Do you understand the rights you have and the penalties that are involved?
Yes, Your Honor.
And Mr. Kukuski, do you know how Mr. Jones wishes to proceed on that?
We'd ask for a hearing at this time, Your Honor.
Okay. And where are we at on the underlying case on the docket?
No, although we've had some fruitful discussions, we're not resolved. So I'd ask for the court for possibly another docket call in regards to the matter.
Any objections?
No objection.
What about July 22nd at 1:20? Does that work? We'll set it for a docket call.
Yeah, that should work.
And we'll set it also for a status conference on the pending violation. When I reviewed the complaint, and I think the prosecutor wanted it brought forward and addressed. It seems to me that Ms. Goodrich, am I misunderstanding the situation if I'm under the belief that this was a fairly technical violation without any harm?
That is correct, Your Honor.
Okay.
And it sounds like from talking to Mr. Kukuski that he has taken that seriously and even didn't go to the last All-Star game. So I would not be asking that bond be revoked or anything today.
Okay. So what I'm going to do is we'll continue this docket call and status conference on the pending violation to July 22nd at 1:20 in the afternoon. I'm not going to revoke your bond on the pending violation. It does sound like it was a fairly technical matter, but you know those technicalities are important in a case like this, and it's important that you follow them and work with your attorney to make sure you're in compliance. It would be my intention to just kind of track this as a status, and if there's no further problems in this area, then this one is not going to turn out to be a problem for you. Okay, but you want to make sure in these kinds of cases, especially. If it comes to my attention that there's a violation involving contact that I find concerning at all,
yes, sir. I
won't do it as a show cause. It'll be a warrant and you'll sit in jail.
Absolutely.
Okay. All right. We'll see you then, sir.
Thank you, Your Honor.
Thank you.
And then council approach, please.
No, I'm totally fine. Like, love it, love it, love it. Can I ask why?